Barton appearing on behalf of the plaintiff, Jeff and Julie Lewis.
All right.
Morning, sir.
And hello, how are you? Hold on.
Good.
And verification in order to seize property. Go ahead.
This is a motion to amend the request and verification order to seize property. It was originally assigned to Moore Associates, and it's been over a year, and my client has contacted them. They haven't done anything. We'd like to have it reassigned to the Washington County Sheriff's Department Judicial Services.
What was their response when they were called?
I'd have to ask my client. He's on Zoom.
Mr. Lewis, what was their response?
Sir, when I asked them back in July, they had indicated that they had basically closed the case because they could not move forward. And then in August, I don't know the exact date, I got a bill from Moore Associates that they actually served her in August with the seizure order. It was like a year after, we'd asked for it. So they have done something in August, but they didn't do anything prior to that, going back to August of 24.
And where are they in the process right now of?
Your Honor, the process server was when I filed this motion. That's when.
Say that again.
The fee that they received, the invoice from Moore for serving the papers they are serving the papers that were in the court here today for, when I filed the motion and to amend the request in order to seize. That's the only thing they've done in a year's time, was serve her with these copies of the papers that I filed in August.
Had they received notice of your motion? And the reason that I ask is because this would be going outside of typically what the court would do.
Yes, they did.
Is a moderate risk. When we reviewed the report, we saw that she was only registering as a low risk, so we assumed that that's what the magistrate used to set the bond initially. That being said, the only criminal history that Ms. Davis has in her past is a domestic violence allegation with her husband from years ago. The allegations in this particular case stem from alleged abuse that occurred with family members in 2004 and in 2019. And one of those, she would have been a minor at that time, living at home with her parents. Another time in 2019 would have been when she was an adult, but had temporarily resided with her parents during that one period during the domestic violence allegation with her husband. That was just for a short period of time during the time in which the court imposed that the parties be separate, meaning Rebecca and her husband be separated. However, she has been married for 13 years to her husband, Lloyd Davis. They have had no issues since that one allegation. She has been a stay-at-home mother for her, this all times relevant to her 5 children ranging in ages from 11 to 1. The ages of those kids, 11, 10, 8, 4, and 1. She has no reason to have any contact with her family outside of her husband and her children. She has led a otherwise law-abiding life during that time. Why she would be classified as a moderate flight risk, I'm not sure. They resided in the same property where she would continue to reside if let out at 1100 14th Avenue, Middletown. They've lived there for the last 7 years. Obviously, with these 5 children, Rebecca has been a stay-at-home mother. Her husband works full-time at a steel facility where he works 12-hour shifts. He is getting some help from the family at this time to help care for these children, but it's obviously difficult and a strain on others. Understanding that, of course, there'd be no reason for any contact with the alleged victims here or that portion of her family. She asked that she be let out on bond, even if it's with electronic home monitoring, so that she can be at home, care for her children, help better prepare for her defense in this particular case from these stale allegations of that occurred years ago, and there's no reason to have any contact. $50,000 for her is just an amount that she cannot meet and does not have the financial resources to do that. And we would ask the court to consider letting her out without a monetary bond posting with GPS monitoring at her home during the pendency of this case.
Thank you, sir. Mr. Goodyear.
Your Honor, today Thomas Davis is present. He's the victim from the 2004 allegation. The other victim is not present. She's actually on vacation today, so she wasn't able to make it. But Your Honor, the state's position, as we discussed in chambers, is that number one, we're talking about 2 felony to third degree gross sexual position allegations involving children. So not only do you have a concern about the normal issues that you may have when considering bond, also, and I'm not saying that she has done or will do anything with her children, but she's going to be around children if she's released, and that's, I think, a concern for the state and for the court as to how to structure this in a way that makes sure that, because of the nature of allegations, we protect other people. Your $50,000 to 10% is what the bond is now. It was originally $250,000, reduced at arraignment to $50,000 at 10%. So a $5,000 bond in reality is what it is. And $5,000 for 2 felony 3 sexual abuse allegations is not unreasonable. In addition to everything we already discussed in chambers, I'm going to go back over everything again. But I think the nature of these allegations are concerning. I think the bond is already at a reasonable amount. We'd ask you to maintain that. But if the court is going to release her, certainly we'd like to see her placed on EMHA while she's released. And I don't know if Mr. Davis, is there anything you would like to say? Okay. He would not like to speak, Judge, but that's our position. We'd ask you to maintain the bond.
All right. At this time, the court is going to modify the bond to a cognizance bond with electronically monitored house arrest, no contact order. The defendant is ordered to not have any contact with Thomas and Tabitha Davis. We have another hearing scheduled in the next few weeks. Is that correct?
Actually, this was a pretrial and bond hearing, Judge, so we need to schedule another hearing.
What shall we schedule it for?
It's really up to the defense, Judge. We have provided discovery now. That was relatively recent. I don't know if they would like to go through it and see if there's any discussion we want to have about a possible resolution, or if they just want a separate trial. I'm not sure how they'd like to proceed.
I have some reciprocal discovery that we're putting together that I can get to Mr. Goodyear. Probably needed 2 to 3 more weeks to do that, just to the voluminous nature of all the correspondence that we're going through. But I think if we were to choose a trial date farther out, I think that would be a good thing to do. And then we can ask the court for another pre-trial if we deem that necessary after we provide the reciprocal discovery.
Let's go ahead and set this for a 2-day jury trial, Mr. Brandon, and then we'll set it for conference with the court sometime before that jury trial. All right, anything else?
No, Your Honor.
No.
All right, thank you all.
Thank you,
Your Honor.
Actually, Judge, I'm sorry. May I ask one more question?
Yes.
So I understand the court's order and the no contact order with the 2 victims. Obviously, she's going to have contact with her own children. But I guess my concern would be
and I understand that, but again, we discussed this in chambers in much more detail than we did on the record just now. There's not been any allegations that the state is aware of with regard to Ms. Davis and her own children.
Right.
These allegations that we're dealing with regard to this indictment are from 2019, so this is 6 years ago. There's been no new allegations that I'm aware of since then. There was nothing in the original bond order with regard to her own children. It was only these 2 alleged victims specifically. It was nothing else about any other children, so I'm not going to change any of that. I mean, has she gotten out on bond? On the original bond order, there was no contact order for her own children. So,
right, and I wasn't going to ask about her own children, Judge. I was just saying that obviously she's going to have contact with her own children. I don't know if the court.
Well, she's on house arrest on a monitor. I don't know what else. I mean, I don't know how else. I mean, that I've done that for the protection of the public, but again, without there being any other allegations other than these 2 older allegations. Again, we're talking 5 or 6 years. There's nothing more recent. I don't see the potential for harm, at least. From where I'm sitting. So again, I think we need to deal with these allegations and then unless the state has other information.
Just to be clear, I was simply going to say, Judge, I wasn't referring to her own children. Okay. What I was going to say is I know oftentimes in cases like this, the court would place an order of having no contact with other children. And I didn't know outside of her children where the court wanted to do that, because that's a common order. That was only my question.
Okay, well, with her being on house arrest at this point in time, Mr. and Mrs. Davis, so you're not to have any other children in your home other than your own children. Let's just make it that, okay? So as long as you're not leaving the house and there's no other children coming to your house other than your children, that should satisfy protection of anyone else, okay? All right, thank you all.
Thank you, Judge.
Thank you, Judge Timothy.
Did.
They did. I don't have a proof of service, but I have it on Jennifer Lout.
All right,
I
I'll have
don't have a proof of service on Moore and Associates. Here's what I will do. And I will make sure that, well, I guess I'm trying to figure out are JF Moore and Associates aware of this motion?
to the best of my knowledge, yes.
Yes.
Well, how do we know that?
I'll have to file a proof of service. I didn't do that, Your Honor.
But it was served on them?
I'm not, yeah, I mailed it, but
I don't know what that answer was.
I mailed it, so first class mail, and I will indicate that in my proof of service.
Well, the proof of service, we will also, and I guess in this instance, I could certainly contact them, or could just issue it, but I don't want to get into a process where people are picking their process servers this way. So what I will do is I'll need the proof of service, make sure that a copy gets to Ms. Weidling. And then I will also have my staff contact them to make sure. And if nothing's been done, then I'll sign your order.
All right, thank you, Your Honor.
Thank you, Your Honor.
Well, he's got to know about the motion, and I want to know what the status is on it.
Okay.
All right, thank you.
Thank you, sir.
Court does call the case of Lakestone Apartments versus Amanda Hentula.
Good morning, Your Honor.
Good morning.
Attorney Samantha Sprague, 1931, appearing on behalf of the plaintiff.
All right, is Ms. Hentula here?
She is.
Oh, well, come on up. It's your case too. Yeah, me either, but I think that's how it works. All right. That's okay. Your name? All right. Where are we on this case?
Your Honor, there is still outstanding rent due and owing. We do show that currently there is past due rent in the amount of $8,140.70. There are late fees currently in the amount of $225. That does reflect three $75 late fees. We are aware of the court's position on that. So we do have numbers for the $75 according to the lease, as well as the $30 that the court has traditionally permitted in the past. And then we also have charges of $160 for washer and dryer fees, utilities in the amount of $239, and court costs in the amount of $327 for a total due and owing of $9,089.70 per the terms of the lease. However, given the reduction for the late fees, the total would be $8,954.70 for the requested judgment.
All right. And what is your position, ma'am?
Well, I think there was just a big miscommunication. Earlier this year in April, they had me sign a lease addendum that I provided for the court. The opposing counsel had a less rental amount. I signed all the paperwork they gave me. I gave them everything they asked for. I dropped it off at the leasing office. They were closed over the weekend, and I didn't hear back from them for 40 days. And at that point, they said, you need to sign a new lease addendum with a new rental amount. So under legal counsel from a legal aid clinic, I didn't pay anything because I didn't know what to pay. But I don't want to keep coming to court, and I just want this to be done and over with. So I would like to.
That's how I feel on a lot of things,
Yeah.
but go ahead.
I'm sorry.
No, it's okay.
I would just like to pay September's rent.
Have you figured out what the difference would be between what you're being charged now, I'll put it that way, as opposed to what it would be under this first lease?
The first lease, well, I'm not sure what exactly I should pay. Like, should I pay the lease addendum that I signed for, or the amount that they want me to pay? Because
well, I'm asking what would be the difference between the two? Have you calculated that out in your head?
Well, it would be $1,259 versus I believe $1,492 per month. I believe that's, so it would be like 200 and, I'm not very good at math, 240 maybe.
Say those numbers again.
1,259 versus 1,492.
You guys are supposed to do this math for me, but you don't care. You know, you just don't care. That's fine. I got it.
I'm very
I have 233 a month difference.
okay.
And what is plaintiff's position on that?
Plaintiff's position is they acknowledge that during the initial recertification, as part of the recertification documents, the lease was signed by Ms. Hantula. It was never fully executed because it was the rental amount for a 1-bedroom, whereas Ms. Hantula is not in a 1-bedroom. She is in a 2-bedroom. When management realized their mistake, they did contact Ms. Hantula. She refused to sign the updated one, as well as refused to provide recertification documentation, which is still outstanding on her account.
So this is subsidized?
It's a low-income housing tax credit.
Got it.
So it doesn't, she doesn't receive a voucher or Section 8, but it does require annual recertification to make sure that she fits the income parameters.
Ma'am, is that part of the distinction, I guess?
Well, when I had spoken to Sabra, who is, I consider my landlord, I had asked her if a different 2-bedroom was available, because on the company website, there was a 2-bedroom that was in this price range. It was 1,200 something. Can we move it? Can me and my son, Max, who's 10 years old, can we move into this 2-bedroom that's available on the website when my lease is up? And she said, no, that's not available for you to move into. So when I signed this addendum,
Which, the first one?
Yeah.
Well, the one that you signed.
Yeah,
Go ahead.
renewing my lease, I had assumed that since the other 2-bedroom wasn't available, then I would be getting this price, and said, like, there was nothing that made me think that this wasn't a valid, contract. Like, they gave me it to sign. I signed it. I gave them all the paperwork, my pay stubs, my child support.
I get all that. I guess what I'm trying to figure out is, at least I think what plaintiff is indicating to me is that the lease you signed was really for a 1-bedroom
Well,
as opposed to a 2-bedroom.
but it had my apartment number and everything, like it had all of my information. And there was a 2-bedroom available for that price, and there still is on the website. So I thought that I was getting,
No, I hear you. I guess I'm,
like there, and then they waited 40 days. Like I didn't get any paperwork back. I didn't get any, they waited 40 days to tell me, oh, hey, you need to sign a new lease addendum. So,
well, okay. So that was going to be my next query. You signed this agreement for this lower amount. Did you then pay rent
I did not,
at the lower amount?
no, because it was for the next month.
You have to help me with that because
This was in the beginning of April when I signed the new contract, and then the new lease was starting in May. So a month went by, and then I noticed on the resident portal when you log in that it had a different rent amount. And so it was like about 40 days later, I emailed Sabra and I said, what's up with this? And she said, oh, you need to sign new paperwork. I'm going to leave it on your door for a new rental amount. That's the amount you need to pay. So I didn't pay anything, which I wasn't sure if I was legally what to do really in that situation. I just sort of.
well, the reason I asked that question is because you're indicating to me that you sign this document and then it's 40 days later that but you didn't pay that lesser amount.
I didn't, because they told me that the lesser amount.
What were you, that wasn't your move-in date, right? Was it?
That was my lease renewal date, because I've been there for a year.
Okay. So what was your rental rate prior to?
It was 1,492.
1,492. So that's what you paid prior to this April time?
Yes.
Okay, so what makes you think it wasn't an error on their part?
It wasn't?
Because your rent went down.
Right. Well, because they gave me a legal contract and I thought they are, competent apartment complex that was
Yeah, but
a legal contract to sign.
and I don't have a problem enforcing a contract. I don't have a problem doing that. But my understanding is they did not execute the contract. They did not sign it. So basically, the contract can happen in this way. If I were to determine that that's an offer, although it might be a mistake on their part, there has to be something on your part that would lead the court to believe that there would be some acceptance of that offer. Then they might just be stuck. The problem here, and that's why I was asking, one of the ways of showing that acceptance would be payment.
Oh.
Okay, so they make this offer to you, you pay, and then I'm not saying that the court would decide that, but then you may have a binding contract then. But then here's the other part. And sort of, does this offer, they're saying it was an error on their part, basically. So then the question in my mind becomes, does it make sense that would be an error? Well, it might, because your rent was what, $14.92, and then it drops, what, $233. That would seem kind of odd, wouldn't it?
Well, I guess I had just assumed, which may have been a mistake on my part, that since the other 2-bedroom wasn't available to rent, that was in that price range, that I was given this amount. It was like the same price.
But they told you, according to what you're telling me, they told you at that point that
Wasn't.
that was not available.
But then why even give me a contract with that amount on it? I was so excited that, I thought that since that it wasn't available, that, the landlord was being nice and like giving me the same price, even though it wasn't the same 2-bedroom apartment. Even though that wasn't communicated to me, I guess I just assumed that it's just a contract that they offered me.
Understood. But what I guess I'm getting at is, let's assume they were being nice. Let's assume that this was a legitimate price.
Excuse me.
There's no payment or attempted payment.
That was a mistake.
And that's, as I see it, that's the problem. Because if somebody were to give me something, if my mortgage payment went down, I'm paying that immediately, right? Because, but the thing is, here, there's no payment.
I was advised not to give a payment in case something went wrong, like I was immediately evicted, that I would need that money as like something to fall on in case it was ruled against me. I was told that. Like I was given all these different possibilities of what could happen, and
Yeah, but I'm assuming that's later down the road and not immediately out of the gate. I'm talking at the point at which they give that contract to you. That was in April, and then you're coming up on May. In May, there isn't a tender payment at that lower rate. And in there, that's where I see, and then they notify you really in 2 ways. One, although I don't know that this is really a notification, the portal says something different, right? And then they notify you otherwise that that's not the amount.
right.
Okay.
Okay.
What's wrong?
I'm just feeling nervous. I'm sorry.
Okay. All right. So let me ask you this. If I were, because here's what it seems like to me might be the decision that the court would come to in this case. Prior to this document appearing, you're paying $14.92, right? The rental rate, so you're coming up on your lease renewal, and if nothing happens on the lease renewal, typically in most cases, you're paying the same amount that you were paying before. It would just continue, which is what really is happening here. Okay.
Okay.
It's all right. Now, if I were to rule that way, the question then becomes, you're about $9,000 in the hole here, right?
A lot of money.
Okay. So I'm going to ask the hard question now, okay?
Okay.
If I were to rule for the plaintiff that you owe this amount, And that, let's say I just made up my own statute and I said, you need to pay that today. Okay, you're shaking your head because you anticipate my question. You don't have that, right?
I do not have that much money. I'm not. I can pay rent.
Hold on a second.
Okay,
Hold on.
I don't have. Yeah.
Are you in a position to move? Okay. So let me try to paint this picture in my head a little bit, okay? If you don't have the money, you're not in a position to move, and I'm assuming your little one just started school, I don't know how, right? So now you have a little one in school, and you're trying to figure out where you're going to go from there, right?
Mm-hmm.
Okay. And not only are you nervous, you're scared to death right now.
I really don't want to be here. I'm sorry.
It's okay. Really, seriously, there are days I feel that way. All right, myself. All right. So now my question becomes, what would be your way of trying to get this done?
I would like to, because it sounds like,
Hold on a second.
Okay.
Hold on a second. What's this case? Okay. What I'm going to do is let me pass the matter briefly. I'm going to talk to the two of you and back.
Okay.
See what we're going to do. Okay.
okay.
And let me try to get a couple of things out of the way, and then I'll have you in back. Okay.
Okay, thank you, Your Honor.
You need to hold on to that? Okay, yeah. This is required.
Court does call the case of Ping Shin versus everybody's coming up. Come on. Versus Caillou, is it Apacapong? I mess that up every time, right? You have an interpreter present. May I have the interpreter sworn?
Raise your right hand. Do you solemnly swear and affirm that you will interpret accurately, completely, and impartially using your best skill and judgment, and to translate from English into Chinese and from Chinese into English in the matter now before the court, so help you God?
I do.
All right.
Good morning.
Good morning, Madam Interpreter. All right. State your name for the record, sir.
Yes, Christina Chen.
All right. State your name.
Ping Shen.
All right.
I'll say aye.
All right. And why are we here today?
Yeah, I just make sure the attendants when they can make payment. Because but for this year, February 9, the hearing judge 就说这个判那个法官判的是3月到8月份，每个月，今年 for this year， 今年8月份3到8月份每个月付500块钱，结果他付了3个月就没付了。
Judge had already ruled that the tenants should pay the delinquencies for $500 a month until August of this year. However, he only paid 3 months and he stopped.
Yes. How much is owing?
总共是多少他欠的钱？
总共欠
$1,149.49.
Hold on a second. Go ahead. How much do you claim is owing?
总共是一共是2600 16块吧，现在赔了3个月，还剩1146啊，是多少？
3个月1500嘛，
对，
就是1116这样是吗
OK.
Your Honor, the delinquency is 2,616, and he paid 1,500 for 3 months, up to total 1,500. So there's still a balance of 1,116.
1,116.
Yes. 1116嘛，对哈 Yes, Your Honor.
Sir, how much do you think is owed?
你认为多少钱？
Excuse me, it's $1,100.49.
1,149.
它是1100块4毛9分差距。
1551 difference. All right.
15块5毛9的差距。
Okay, go ahead.
This just all been so much, and it's been going on for so long,
这
so
个已
it's
经
just
花了很长的一段时
like
间，
stressful.
非常的这个。
Me and my family have been trying to figure out how to pay it, but my wife is an educator. She's a school teacher. She doesn't work over the summer, so she just literally went back to work last week. I have a family of 7. Me, my 4 kids, my wife, and I take care of my mother. So
Okay, so let me ask you this. When do you think you can get this paid?
你什么时候可以付他？
to be honest with you, I'm not entirely sure.
我不敢确定。
I've been trying to figure out the billing process with my wife to try to get everything down since I was only working. We got a little behind on everything, so trying to play catch up.
Okay, let me
各方面都付款的情况。
let me ask you this. If I were, because the court has the ability to do that, sort of restructure your payment,
如果法庭能够重新
how much do you think,
方式，
as you stand here right now, how much do you think you could pay per month?
See if it's $1,100.
总共是
To be completely honest with you, it couldn't be any more than $200 a month.
他说最
Or
多一个月我付
I mean, that's
超过
kind of
200块。
stretching the little.
Hang
Yeah.
on, hang on.
就是一个金额。
So that was
Sometimes you say too much.
有的时候你讲话讲太多了。
yeah. So about $200.
Well, let me ask you this.
200块。
Well, if I can just get more time, can I get
Sir,
till?
sir, please.
希望他只讲个不停。
Cut the payments to 250 per month, understanding the summer work schedule or payment schedule.
50块钱可以吗？
When could you start those payments?
可以开始付这个钱，250一个月。
October.
October 1? Because you got,
15.
well,
My wife she gets paid twice a month.
我太太
So
每
she
个
doesn't
月
even really
收
get her
2次的
check
薪水，
until the
一
15th.
个月可以拿2次支票收入。
so here's what I'm going to do. I'm going to indicate that the current balance, I'm going to take the plaintiff's number of $1,116. Defendant to pay $250 per month
250块，
beginning October 15th,
付的话是10月
2025. So I'm giving him time to pay it off, realizing the work schedule and the payment.
现在已经给你时间，让你能够按时可以来付这个钱。
But I'm taking your number, which is a higher number, as to what's
把
it.
你的数字哈为这个比较高的这个数字为欠款的标准。
All right? Thank you.
By the way,
你要说什么？
I prefer he can pay to the court escrow account, not pay my director.
That's how it's set up, sir.
Pardon?
That is how it's set up.
Well, that's because you guys couldn't do stuff right.
啊，所以
So
是利好。
pay $250 per month, beginning October 15th to the court escrow.
好，是
All right.
晚上哈。
Thank you.
Okay, thank you.
Thank you.
Okay, thank you.
Thank you, Madam Interpreter. R&J Group Holdings versus Lazar. Sadeji Stanfield.
Morning, Your Honor. Anthony Momena appearing on behalf of plaintiff R&J Group Holdings.
Really?
Yes.
All right, what are we doing?
Hopefully, Your Honor, we're denying her motion based upon the reasoning given in my response in opposition to defendant's emergency motion to compel plaintiff to return security deposit and expenses.
Her motion is denied on its merits.
Thank you, Your Honor.
All right.
Question to the court.
Oh, boy.
Good to see you, by the way, again. Hopefully, we have to stop meeting like this.
Yeah. Just,
Deeply as charged to the indictment.
All right. And Ms. Diefenbach, is that accurate?
Yes, sir.
Okay, Ms. Norman, they're telling me you're going to change your plea to guilty to the two counts of the indictment. Before I get to your change of plea, I am required to go over some things with you, okay? How old are you?
I'm 41.
How far did you go in school?
Some college.
So you can read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
Yes, sir.
Has anyone promised you how the court would sentence you?
Sorry.
I don't know what I'm going to do. So when I ask people that, since I don't know what I'm going to do, no one has the authority to promise you anything. Would you agree with that?
Yes, Your Honor.
All right. Has anyone threatened you in any way to get you to plead guilty against your will?
No, Your Honor.
Are you satisfied with the representation you've received from Ms. Diefenbach?
Yes, Your Honor.
Are you currently under the influence of any drugs or alcohol?
No, Your Honor.
Do you take medication that interferes with your ability to understand what's going on today?
No, Your Honor.
I have in front of me a document. It's called a change of plea. On the second page on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, Your Honor.
And you believe you understand what it says?
Yes, Your Honor.
This document says you're entering a plea of guilty to one count of domestic violence as a felony of the fourth degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The second count is one of aggravated possession of drugs, a felony of the fifth degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison terms are not mandatory. Do you understand the maximum penalties involved?
Yes, Your Honor.
Now, you're also subject to a discretionary period of post-release control, which means that if you are sent to prison upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time you get sentenced to. Do you understand that?
Yes, Your Honor.
But as I've said, it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, Your Honor.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, Your Honor.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people. and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty and the verdict must be unanimous. Do you understand that?
Yes, Your Honor.
At that trial, you have a right to see and hear all the evidence that the state has against you with the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, Your Honor.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, Your Honor.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, Your Honor.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, Your Honor.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, Your Honor.
Do you believe you understand each of these rights we've discussed?
Yes, Your Honor.
Do you understand that when you enter a plea of guilty, you will be waiving all these rights? We will not have a trial.
Yes, Your Honor.
This is how you wish to proceed.
Yes, Your Honor.
All right.
Your Honor, if this case would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about July 20th, 2025, in the city of Lebanon, Warren County, Ohio, Lebanon PD responded to the defendant's home for the report of a domestic violence in progress. The victim is her husband. He indicated that he was struck on his left arm and the left side of his neck. Police observed visible red marks on his left arm and the left side of his neck. Additionally, the defendant's 13-year-old son witnessed the incident and told police that the defendant jumped on the victim and was the aggressor. She does have a prior conviction for domestic violence and a search incident to arrest located 0.24 grams of methamphetamine in her pocket.
Ms. Diefenbach, anything on those facts?
Nothing on the facts.
Ms. Norman, did you hear the statement that she read?
Yes, Your Honor.
You admit and acknowledge what she said is true.
Yes, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, the rights we discussed.
Yes, Your Honor.
What is your plea?
I plead guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we discussed. The court will accept your plea of guilty. Based upon the statement of facts in your plea, the court will make a finding of guilty. I will order a pre-sentence investigation, Ms. Norman, and we'll come back in a few weeks and do sentencing at that time. Is there anything else?
No,
Yes, sir. I do have something. I did not realize that there would be a representative here today from Be Strong Ministries. Behind the officer there, she's the representative, and they are willing to take her to residential programs. The court would change her bond to like an OR with a monitor.
Without you providing some of the victims here,
Victim is not present.
without you providing notice to the victim under Marcy's law, I'm not allowed to modify the terms and conditions of her bond. So
Okay,
if you wish to have that considered, you're going to need to file a written request
okay,
so that the victim can be notified and have input into the decision. Not that they control it, but they are entitled
yeah,
under
I can file.
Marcy's law to notice of any bond modification.
Okay, I can do that.
All right, thank you.
I'll do that. Okay, something fun.
Okay.
Okay,
Thank
thank you,
you.
sir.
Mr. Ladd? Yes.
Oh, I don't know where that goes.
That's,
Probation ticket? No.
yes, they'll take it. It's his monitor.
Will you?
Yeah.
Okay, I still have that. I'm on there.
Okay, sorry, I didn't know what that was. Thank you.
This is case number 25CR42460, the state of Ohio versus Tavon Simmons. Mr. Simmons is present and represented by his counsel, Mr. Bliley. Ms. Tranter, on behalf of the state of Ohio. Ms. Tranter.
Your Honor, it's my understanding that Mr. Simmons is prepared to change his plea this morning. He's going to be entering a guilty plea to count 1, child endangering as a felony in the 2nd degree, count 2, importuning, felony in the 3rd degree, count 5, illegal use of a minor in a nudity-oriented material or performance as a felony in the 2nd degree, as well as count 6, illegal use of a minor in nudity-oriented material as a felony in the 5th degree. We do have an agreed proposed recommended sentence to present to the court of a minimum term in prison, minimum definite term of 7 years to a maximum indefinite term under Reagan-Tokes of 10.5 years, as well as the registration requirement of being a tier 2 sex offender.
Well, Mr. Bliley, is all that accurate?
It is, sir.
Okay, Mr. Simmons, they're telling me that you wish to change your plea to some of the counts of the indictment with an agreed recommended sentence to the court. Before we get to that part of it, I need to go over some things with you. Okay, sir?
Yes, sir.
How old are you?
I am 20.
How far did you go in school?
I got some college.
So you can read and write?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
Has anyone promised you how the court would sentence you other than this recommended sentence from the state and your counsel to me?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, Your Honor.
Are you satisfied with the representation that you've received from Mr. Bliley?
Yes, Your Honor.
Are you currently under the influence of any drugs or alcohol?
No, Your Honor.
Do you take medication that interferes with your ability to understand what's going on today?
No, Your Honor.
I have in front of me a document that's called a change of plea. On the 3rd page of this document, on the line marked defendant, there is a signature. Did you sign this document?
Yes, Your Honor.
Did you read it and go over it with your attorney before you signed it?
Yes, Your Honor.
And you believe you understand what it says?
Yes, Your Honor.
Do you understand that you are pleading guilty to at least one offense that carries what's called an indefinite sentence?
Yes, Your Honor.
You understand that you're also pleading guilty to 3 other charges, even though one of them would be a qualifying indefinite sentence. I'm only going to sentence you on one of them as an indefinite sentence. So you'll get an indefinite sentence on count 1. And then on count 2, the maximum penalty is 36 months in prison and a $10,000 fine. Count 2, the maximum penalty is 8 years in prison and a $15,000 fine. Count 6, I said the wrong counts. Count 5, count 6 is a felony of the 5th degree and carries a maximum penalty of 12 months in prison and a $2,500 fine. And you understand that on count 1, the court is going to impose an indefinite sentence.
Yes, Your Honor.
You understand that you're going to receive both a minimum term and the maximum minimum term on that is 12 years, or it's 8 years in prison. The longest maximum term sentence on that is going to be 12 years. You understand that?
Yes, Your Honor.
And then you understand that the court's going to be selecting a number between 2 and 8 on that account, and then that will be the minimum term sentence. The maximum term will automatically be calculated to be whatever number the court selects plus 1/2 of that number. You understand that?
Yes, Your
Does it
Honor.
make sense so far?
Yes, Your Honor.
Okay. And then the court will select from the range of penalties for each of the other offenses, and the court will then decide whether those offenses run concurrent with count 1 or consecutive to count 1. Do you understand what those terms mean?
Yes, Your Honor.
I'm going to sit here and do some math real quick. So, and again, this is not meant to frighten you in any way, but just so that you understand that the longest minimum term sentence that you could receive is 20 years.
Yes, Your Honor.
The longest maximum term sentence that you could receive is 24 years. Ms. Tranter, is my math correct?
I believe so, Your Honor.
And again, that would depend on, that would be the court ordering the maximum sentence on each of the offenses, all of them to run consecutive with each other. You understand that?
Yes, Your Honor.
All right. There is a rebuttable presumption of you being released after you've served the minimum term. You understand that?
Yes, Your Honor.
The Ohio Department of Corrections may rebut that presumption through an administrative hearing process and thereby maintain your incarceration for reasonable periods of duration up to the maximum term And in this case, that would be 24 years. You understand that? The criteria for the Department of Corrections to rebut that presumption and to maintain your incarceration after serving the minimum term or presumptive after serving the minimum term include the following. During incarceration, you commit a rule infraction that compromise of prison security, compromise safety of staff or inmates, cause or threaten physical harm to staff or inmates, or commit a violation of law that was not prosecuted, and any infractions or violations which demonstrate you have not been rehabilitated, and or that your behavior demonstrates that you continue to pose a threat to society. Number two, regardless of your classified security level at the time of the hearing, you had been placed in extended restrictive housing within the year preceding the hearing date. Or number three, at the time of the hearing, you are classified by the Department of Corrections as a security level 3, 4, 5 or higher. If the Department of Corrections rebuts the presumption, the Department of Corrections may maintain your incarceration in a state correctional institution under the sentence after the expiration of the minimum prison term or after the, keep on wanting to throw in the presumed early release date, but it doesn't apply in this case.
Correct.
For an additional reasonable period of incarceration to be determined by the Department of Corrections, not to exceed the maximum prison term. Also, the Department of Corrections may maintain your incarceration more than one time up to the maximum term. The Department of Corrections shall release you at the expiration of your maximum term if you've not already been released. You are not entitled to receive what's called the earned ERMPT or earned reduction of minimum prison term credit because these are sex offenses. So you're not eligible to receive that. Do you understand all of these admonishments that I've given you on this?
Yes, Your Honor.
You will also be required to register as a tier 2 sex offender, which I will go in more detail at a later time. You understand that?
Yes, Your Honor.
You're also subject to a mandatory period of post-release control, which means upon your release from prison, the Adult Parole Authority will supervise you for a mandatory period of 5 years. If you violate that supervision, the Adult Parole Authority can return you to prison for up to 1/2 of this court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, Your Honor.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, Your Honor.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty and their verdict must be unanimous. Do you understand that?
Yes, Your Honor.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, Your Honor.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, Your Honor.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, Your Honor.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, Your Honor.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, Your Honor.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, Your Honor.
Do you believe you understand each of these rights we've discussed?
Yes, Your Honor.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, Your Honor.
This is how you wish to proceed.
Yes, Your Honor.
Ms. Tranter.
Your Honor, in addition to the facts that are alleged in the language of the indictment, these offenses occurred between the time of February 26th of 2024 through August 20th of 2024 in Hamilton Township. At that time, the defendant was in contact with the victim in this matter, who at the time was 10 years old, via a chat app called Discord. He did solicit her numerous times to engage in sexual conduct, and did also encourage and solicit her to send photographs, nude photographs to him via the app.
Mr. Bliley, anything on those facts?
Nothing on the facts, Judge. All I want to say is everything the judge said was consistent with what I talked to you about.
Yes, sir.
Nothing further, sir.
Mr. Simmons, did you hear the statement that she read? Were you listening to what she read?
Yes, Your Honor.
Do you admit and acknowledge what she said is true?
Yes, Your Honor.
And again, you understand all the rights you're giving up entering a plea of guilty, the rights we went over.
Yes, Your Honor.
What is your plea?
Guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Any reason why we should proceed directly with sentencing?
No, Your Honor.
Ms. Tranter, anything on behalf of the state?
Your Honor, I do have Ms. Laurel here, who does have a victim impact statement we would like the court to hear.
Do we move out of the way?
No,
She
she knows where to, she'll just go over there.
Yeah.
She's fine.
Morning, Your Honor.
Good morning.
This is from the victim's mother. Her name is Carrie Seiler. Hello, as a mother to a once outgoing and social, now 12-year-old daughter, Trayvon has now changed her outcome and perception of the world. She has feelings of guilt, anger, and because of the loss of her innocence, Trayvon has taken from her. She struggles with trust, fear, and anxiety. This crime did not just affect my daughter, it also makes me feel like I did not protect her enough from social media and technology. When she was only trying to make friends and play games online, her perception of the world, safety, and relationships has been warped. This is requiring a long and difficult healing process. I hope his sentencing teaches him that it is not okay to take advantage of vulnerable young children in the future, and that this will never happen again. And I apologize, Your Honor, this is the grandmother, Carrie Seiler.
All right, thank you. Anything else, Ms. Tranter?
Nothing further, Your Honor.
Mr. Bliley?
Your Honor, Trayvon's socially awkward on this, and he fully acknowledges his role in this. He fully accepts responsibility of this. Absolutely. It really hit home with him when he actually saw the evidence of the impact of what he's doing. Unfortunately, in today's world, when you see words, you don't necessarily connect it. Even though there's ages, there's sex and race and all the other things on words, you don't necessarily see a person. It's not an excuse by any means. This is a case that has been discussed between several, at least another attorney in my office. We asked that you impose the agreed upon sentence. It's been long debated. I say debated, discussed about what is a fair conclusion. We do ask that you impose the agreed upon sentence, Your Honor.
Thank you. Mr. Simmons, is there anything you'd like to say before I pronounce your sentence?
I would like to say that I am very sorry. This has impacted me in a way that I never thought I would really feel, and it hurts a lot knowing that I did that. And I just wish the best for everyone in this case, family, daughter, everyone.
Court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So on count one, the court is going to order you to serve a minimum term sentence of 7 years, maximum term sentence of 10.5 years. On count two, the court is going to order you to serve 36 months. That to be served concurrent with count one. On count five, the court is going to order you to serve a sentence of 7 years, again to be served concurrent with count one. And on count six, 12 months in prison, again to be served concurrent with count one. Now, you are also subject to this mandatory post-release control. So upon your release from prison, the Adult Parole Authority will supervise you for 5 years. You understand that?
Yes, Your Honor.
If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original minimum term sentence. So that would be 3.5 years by the Adult Parole Authority. If your violation is that you commit another felony, you can be returned. You can be sent to prison by that sentencing judge for 1 year or the period that you have left on PRC, and that time would run consecutive to any additional prison time that judge sentences you to. You understand that?
Yes, Your Honor.
Do we have a jail time credit?
I'll look at it. Sorry.
The court finds that he's indigent for the purpose of any fines, costs, or other financial sanctions. Now, we spoke when I was doing the sentencing, I talked about all of the criteria that the Department of Corrections follows in order to determine whether or not you need to be held beyond your minimum term of imprisonment. Do you want me to go over that with you again?
If you would, Your Honor, yes, please.
Okay. There is a rebuttable presumption that you will be released after you serve the 7 years, which are you're not entitled to the earned early release that we've already discussed. Now, the Department of Corrections may rebut that presumption through an administrative hearing process, and they may maintain your incarceration for reasonable periods of duration up to the maximum of 10.5 years. The criteria for the Department of Corrections to rebut that presumption and to maintain your incarceration after you serve your minimum term are the following. Number one, during incarceration, you commit a rule infractions of the prison that compromise the prison security, you compromise the safety of the staff or inmates, or you cause or threaten physical harm to staff or inmates, or you commit a violation of law that was not prosecuted, and any infractions or violations which demonstrate that you have not been rehabilitated or that you continue to pose a threat to society. Or number two, regardless of the classified security level at the time of the hearing, you had been placed in extended restrictive housing within the year preceding the hearing date. Or number three, at the time of the hearing, you had been classified by the Department of Corrections as a security level 3, 4, 5 or higher. If the Department of Corrections rebuts the presumption of your release, they may maintain your incarceration in a state correctional institution under the sentence after the expiration of the minimum prison term for an additional reasonable period of incarceration to be determined by the Department of Corrections, not to exceed the maximum prison term. They may also maintain your incarceration more than one time up to the maximum term. All right, the rest of it has to deal with the ERMPT, which does not apply in this case.
That all makes sense.
Yeah.
Don't screw up.
All right, you have now been convicted of a sexually oriented offense or a child victim offense as defined by the Ohio Revised Code, and you are now classified as a Tier 2 sex offender. You are required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if temporarily domiciled for more than 3 days. You're also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here, you're also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You're also required to register in person with the sheriff of the county in which you establish a place of employment if you've been employed for more than 3 days or an aggregate of 14 days in a calendar year. If you establish a place of employment in another state but maintain a residence or temporary domicile here, you're also required to register in person with the sheriff or other appropriate official in that other state if you've been employed for more than 3 days or an aggregate of 14 days in the calendar year. Employment includes volunteer services. You're also required to provide to the sheriff temporary lodging information, including address and length of stay, if your absence will be for 7 days or more. After the date of initial registration, you're required to periodically verify your residence, address, place of employment, and or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change residence, address, place of employment, and or place of education, you shall provide written notice of that change to the sheriff with whom you most recently registered and to the sheriff in the county in which you intend to reside, or establish a place of employment and or place of education at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address change is not to a fixed address, you shall include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address, you must register with the sheriff that fixed address. You're further advised in accordance with federal law, you must report any international travel to your registering authority no less than 21 days prior to travel. Failure to do so may subject you to criminal prosecution. You shall provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers registered to or used by you to the sheriff with whom you've most recently registered. You are required to comply with all of the above described requirements for a period of 25 years and in-person verification every 180 days. Since your expected residence after your release from prison is stated in Hamilton County, you shall register in person no later than 3 days after your release with the sheriff's office in Hamilton County. Failure to register, failure to verify residence at the specified times, or failure to provide notice of a change in residence address or other required information as described above will result in criminal prosecution. Now, you have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Tranter, did I leave anything else?
No, I get 61 days credit, Judge.
61 days jail time credit. Does that sound about right, Mr. Simmons?
Yes, Your Honor.
All right. Mr. Blatley, is there anything else, sir?
There is nothing.
All right, Mr. Simmons, good luck to you. There's a deputy standing behind you. You are now being taken into custody. Your bond is revoked. You're remanded into the custody of the Warren County Sheriff for transport to the Department of Corrections.
Thank you.
Thank you.
Do you want this back or?
Thank you.
Will you be providing a denial of the motion on her order, or should I submit one?
Submit one, please.
Thank you.
Already.
Is there any chance?
I could do it today, so I can sign it. We don't even have to do it. Okay.
Okay, is it electronic or do I need to get one? Are we
You
electronic?
if you get it and send it to Ms. Weidling,
Okay.
it'll get signed.
I believe I have plenty of examples of your email address. Thank
All
you,
right.
Judge. Have a good day.
Thank you. Can you write that in there? She can't grow.
Oh,
All right.
I need to do something else. I just don't necessarily.
Well, find out who's ready. Let me try to get these two. Can you get them to the jury room, please? These two, yes. Right here. Just follow my bailiff back, man. You got anybody else ready?
It's Laurie Anderson.
It's gonna be a trial, right? Well, that's your motion, and we got a whole other thing with that. On that one, what's Fink doing?
Mr. Fink potentially had one that was a short matter. Is that true?
If the Buckners are here, perhaps, if I could talk to them briefly.
Go ahead and talk to them. Why? What's Tish Lee doing here?
She's got two final settlements with Mr. Fink.
And then, Your Honor, the determined matter, which is with Ms. Lee, we've resolved it. We've got to reduce it to writing. And then I think we have 3 other ones where.
3?
I'm only from one other one.
It's a day after a holiday. Well, you can't, never mind. Court of stand in recess. And she got one other.
Maybe see. You young man.
in lieu of what the court could do, but I think this is a fair solution to this, that after a hearing in this case, the court is going to award plaintiff a judgment in the total amount of $8,956.70. That comprising rent of $8,040.70, other fees, and that includes costs. It is ordered that the defendant will pay this amount by September 15th, 2025, or a writ shall issue. A money judgment is issued in the, I think it was requested. Money judgment is issued in the corresponding amount. The court is going to allow defendant an opportunity and to try to get this paid off. That if the defendant pays $4,000 to plaintiff on or before September 15, 2025, no writ shall issue in this matter. Defendant will then be on a monthly payment plan if $4,000 is paid to pay off the remaining amount of this judgment. And she will make timely monthly rental payments on or before the 1st of October, 2025. In addition, there will be monthly payments of $825 beginning October 15th. So there'd be two payments that month if the $4,000 is come with, until the balance is paid in full. There will be no late fees will accrue while she's paying this off. The 56-day rule is waived. If defendant fails to make payments, a order of eviction shall issue without hearing if it's missed within 5 days after any missed payment. That is what I indicated to the court. Is there any question, or indicated to the parties? Is there any questions from either side?
No, Your Honor.
All right. Thank you, ma'am. Good luck to you. We'll be issuing that. And Ms. Antula, can you get her email and ship that to the front court?
Yes.
All right.
Send it to the front court.
Yes.
Yeah, you can.
Okay. Thank you.
That there's no attorney on either side, but the tenant is not here.
Okay. Terrell Barksdale versus Leo Stringa. Your name?
Sherelle Barksdale.
All right. And Leo Stringa, not here. This is a termination of tenancy action. He also did not file a written answer. The defendant, having failed to appear and comply with the court's orders, judgment for possession will enter. There is no redemption amount. Writ will issue in 10 days. For my signing. So you'll need to fill out a judgment for my signature. Get a copy at the front counter.
Okay.
All right. Thank you. Take care, Ms. Andula. Court calls the case of Steven Weaver versus Eric Buckner. Is this one of Ms. Lee's cases? Oh, and Nicole Winnable.
Morning, sir.
Good morning, sir. Your name?
Eric Buckner.
All right. Where are we on this case?
Mr. Buckner and I have agreed to a COD, which I will submit on the 7-day rule. Should we include the terms as to his wife, who is Ms. Winnable, as a default?
Yes.
And then she's in default, and if we have to come back. So, Your Honor, we agree that today's balance is $5,100.
Okay.
We agree that monthly rent is $2,300. They are going to pay $1,000 today, $700 next Tuesday, and $700 every Tuesday until their balance is zero, but no later than October 31st.
Got it. So
it'll be a total of 51 plus 2,300, which is $7,400 that they'll pay 1,000 today and then 700 a week until it's paid. They'll pay their monthly rent on time through the end of their lease, which is March, right? March. Which is in March. We'll do this as a conditional dismissal. If they comply with those terms, then matter will remain dismissed. If they don't, the landlord is entitled to submit an affidavit of non-compliance to judgment and an order of eviction.
Sir?
Yes, sir.
Is that correct?
Yes, sir.
All right. Do you have any questions regarding those terms?
Nope, I'm good.
Okay. When I do sign it, and I just will advise you, since your portion is really a consent, that you would have 3 business days in which to think about it from the date of my signing. If you believe that there's some legal reason, some right you didn't assert, some misunderstanding or confusion, you'd have to file a motion with the court within those 3 business days. You understand that, sir?
I'm good.
All right.
Thank you, sir.
Thank you for working it out.
I will.
Thank you, Your Honor.
Yeah, thank you.
Okay.
Mr. Hampton's and Miss Patel's.
Ready?
Miss Patel was here and Mr. Hampton just did say yes, he was ready, but I didn't see his towel. Oh, yes, she's back.
No, we'll wait for them to have finished their conversation.
I'm sorry, Your Honor. I was complimenting, I have not seen Mr. Fink in probably since before COVID, and I was complimenting the hairstyle and telling him how much I appreciate it.
I was going to do that myself like that.
Yeah.
But it didn't work.
Let's do that.
Yeah. Karen Steele versus Robin Yash.
Maybe approach. Can we approach, Your Honor?
Oh, boy. Yeah, come on.
Thank you.
All right. In this matter, record should reflect advanced conference with counsel. Really, but surely things are kind of coming through, and I don't mind giving the parties an opportunity to try to get themselves closer. In October, final settlement conference day.
October 14th.
14th. Will October 14th work for council?
Yes, Judge.
Works for me as well, Judge.
Okay. So final settlement conference will be adjourned in this matter October 14th, 2025, 9 a.m.
Thank you, Judge.
Thank you,
All
Your
right.
Honor.
Thank you, folks. Thank you.
You know what that is?
What does,
So
is she ready? She is too.
They are not ready. Final settlements.
On both of Tish's.
That's my understanding. Yeah. One of them he's working on, but he needs it on the other one. He's.
Oh, I thought we
Yeah, yeah.
happy birthday. Yes.
Ms. Lee, you needed final, I thought one of yours was resolved, but not.
We're working on the one that we're trying to resolve. I think we're close, and then the other one.
The other one you need. Okay. I just want to make sure that we were. Okay, that's
So
that.
these are all final settlements. This is your last one. For your final settlements.
So those are all final settlements.
Yes.
This is this one.
Mhm.
They do this. They're gonna start putting a label on the front of these brown files if they're gonna do that.
It's because how
Where is?
Okay. It's a motion.
Lori Anderson versus our money line.
Your Honor, my name is Gary Sagatti, P39057. I represent Ms. Anderson, standing to my left.
All right, go ahead. You had a motion.
Well, Ms. Anderson has asked me to withdraw. I've submitted a motion to the court. I don't object to it. I refunded half of her initial retainer. And if I'm forced to go forward, she'd have to pay me that plus a substantial amount more. And I'm asking.
Yeah, but my
motion.
concern, counsel, is that you enter an appearance in the case, this matter gets set for trial, and then on the eve of trial, there's a motion to withdraw.
It really wasn't on the eve of trial, Your Honor. I sent that on August the 20th. We sent a proposed stipulation. It wasn't a motion. We sent the stipulation, which I signed, Mr. Anderson signed.
So 10 days, maybe you don't look at that as the eve of trial. I look at that as the eve of trial. Are you going to be prepared to go forth today, ma'am, if I do this?
Yes, sir.
I'll be honest with you, counsel. I don't like when attorneys enter their appearance and then withdraw. I don't like it at all. Especially where something gets set for trial. I'll grant the motion to withdraw.
Thank you, Your Honor. I have an order.
You two are ready for trial. You're going to have to wait. I've got final settlement conferences I have to go forth on. So, you guys are going to have to wait. So have a seat. Is she ready to go and back?
I have not been told otherwise.
Are you ready on Ms. Lee's cases? Would it be better if I talk to counsel and back?
I know that Mrs. Sherman needs to go take care of her family.
So we just, we can talk to you on the record about, or at the bench.
If you call the Sherman case, Your Honor, I think we can get this done.
Yes.
New Park Ridge versus Precious Terminal.
Get her out of here, take care of her family. James, thanks to the plaintiff. I could just get Ms. Dorsey, Your Honor.
I don't think they stated their appearances, did they?
So.
Your Honor, for the record, Tish Lee for the defendant, Precious Terman.
This is okay as long as he orders it. Your Honor, I think we have a conditional order of dismissal. I thought I did that when you first called it. James, thank you for the plaintiff.
All right.
Do we want to approach the bench?
Sure.
Okay.
Maybe.
Yes.
Just take a minute. payments commencing October 1st, 2025. If it's the entire balance, it will be $478.50 a month, 6 equal payments for the arrearage, but we expect that she's going to get assistance. And so whatever the balance is going to be divided by 6. That's what she'll pay for those 6 months. It could be as low as $50. She'll pay her monthly rent on time and not later than the 5th of each month. She will timely complete all recertifications, both annual and interim. While this order is in effect, she'll comply with the terms of her lease. If she makes all payments as agreed, no additional late fees shall be added to her ledger. My client can only do that if you order it. And I know from our previous discussions that you order it. So we added it. If she's delinquent, late fees will accrue. If she fails to comply with any terms of the order, we can file an affidavit of non-compliance with a copy to defense counsel. They have 5 business days to file objections. If they object, you'll have a hearing, and it will be based on a preponderance of the evidence, except as set forth in this. The terms of the lease continue. The 14-day objection period of MCR 2.602C2D is waived. The 56-day rule is waived. This order is good for 365 days for enforcement. There's no admission of or a finding of fault or wrongdoing. Court retains jurisdiction, and this is a final order resolving the last pending claim.
All right. Is that a correct statement? Here's the only issue that I have. The additional payment is due at the same time as rent. I have a problem with that. I would rather that the additional payment be due the 15th of the month. And my only reason for saying that is because I just ran into this. I thought about it before, but it just ran into it where they do a recert, the rent goes up, and then there's this huge amount at the beginning. It can be paid if there's like another paycheck.
I'm sorry, Your Honor, they do a research when?
The person did a recert. There was a recert done. Their rent goes up. They had this lump sum payment due. All of it's due at the first. And so their rent went up, and then all of a sudden they had this large payment. There's this payment due.
The arrearage payment?
Right.
You made that change, Your Honor.
Okay.
So 15th now, so commencing October 15th and on the 15th of each month for those 6 monthly payments on the arrearage.
I just think it's easier for tenants to,
Got it.
do.
So instead of starting on October 1st, start on October 15th.
Okay. I mean, if she wants to pay it early, she can. I just don't want them pinched into a box. Are all those other terms correct, Ms. Lee?
Yes, Your Honor.
All right, very good. Thank you, folks, for working it out.
I just sent it to Ms. Weiling, and we will sign it and submit it today.
All right, fantastic. I will
Thank
mark
you.
this file conditionally dismissed. Thank you. Thank you, Ms. Turman. Okay, I've got this one.
The final sign.
This one has Ms. Lee.
That one has, is that McFarland?
Ms. Lee is here on.
Yes, on McFarland.
Yes.
McFarland.
Okay.
You want separate? Okay. All right. Then why don't I don't have 2 rooms back there. That's my problem.
No, you do not. Do you want?
And I don't have a spare courtroom.
Do chambers and the jury deliberation?
Wow.
We can handle it. We can take the hallway as long as I got a place to put my laptop.
All right. Let me talk to them plaintiff first and then I'll. We're standing in recess. They make it remain seated.
Okay, we can get Donovan Spencer. Good morning, sir. Are you Donovan Spencer? Good morning, Mr. Smith. Give me just a second. And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Well, it's coming, hopefully. Did they? Good morning. Good morning. Okay, Mr. Spencer, in cause number 24, DCCR 0261, I have a motion to revoke your community supervision. It shows that you were placed on probation July 17th of 2024 for assault on a peace officer, and that was a 10-year term in prison that was probated for 10 years. Is that correct? And it alleges that you violated your probation. Count 1 alleges that you failed to report as directed July 8th of 2025, and is that true or not true?
True.
Count 2 alleges that you failed to complete the mental health evaluation and follow all of the recommendations. And is that true or not true? Count 3 alleges that you failed to successfully complete the SafeP program. Is that true or not true? And then count 4 alleges that you failed to submit to an alcohol or drug screening July 1st of 2025. And is that true or not true? Did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is to cap your punishment at 6 years. And so what that means is that we will reset your case. I'll get an updated pre-sentence report. We'll come back and see. I'll get any evidence that's presented, and then I'll decide your sentence. And as long as I do not give you more than 6 years in prison, you can't appeal that. You understand? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Spencer is not competent?
Okay.
All right, so I'm going to find that you entered your plea of guilty your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he will present it to me on your behalf when we come back. All right, we'll see you back at sentencing.
Thank you, Judge.
Thank you. And we reset Wilkerson. Ms. Perazo, you have Jose Lopez Pamias.
I don't have an interpreter. Ruben could not be here today. Because I didn't find out until this morning that he wasn't going to be able to make it.
Call. Okay, we have to do something. Okay, I'll hold it while we get an interpreter. You have Trayvon Alexander. Good morning. Let's see if we can get Ms. Cepeda on the phone, but maybe just for a minute if you don't mind. Thank you, Mr. Rojas. Huh? It is. And Charlie could do it for the pre-trial. I didn't think about that.
She's coming back, Judge.
Okay, we're good, Mr. Rojas. Thank you, sir. Good morning. Are you Traven Alexander? And this is 25 DCCR 0831. Mr. Alexander is charged with murder. And Ms. Perazo, what is the announcement?
Your Honor, we have not quite completed reviewing all of the discovery, so if I could just have
Sure.
additional
This
time
is,
to review.
yeah, just indicted, looks like 40 days ago. Okay, and so Mr. Alexander, what I'm going to do is reset your case about 30 days or so to give Ms. Peraza some more time to make sure she has all the discovery from the district attorney's office. She will be out there to go over all of that with you before the next court date, everything that she has, and then we'll see if we can get an announcement at that point. Okay? All right, you can go back with the bailiff.
Is that right? Okay. I think it's not like this happening, getting back on the. Okay.
Mr. LeBlanc, you have Lenny Leday. Okay, good morning. That's right. Okay. Yeah. All right, so you're Lenny Leday?
Yes, ma'am.
And this is 23 DCCR 0783, and Mr. Leday is charged with sexual assault. There was a withdrawal. We've gone through a couple of attorneys. Mr. LeBlanc has been appointed, and Mr. LeBlanc, what is the announcement?
Judge, as far as I understand, his plea is still the same. We're getting ready for trial. I've gotten with his other attorney and got the information from him.
Okay.
And so it's.
No change in any offers or anything like that. All right, so Mr. Leday, what I'll do is move your case back onto the trial docket, and Mr. LeBlanc will continue getting ready for trial, and we'll get it tried as quickly as we can. All right, you go back with the bailiff. Thank you, sir. Ms. Holmes, you have Jordan Thomas.
Yes, ma'am, you can hold them.
He'd like a chance to talk with his family. It is a extensive time offer.
Okay.
And so we were asking if we can get, even if it's a short recess, so he can have time to discuss with his family.
Okay. We'll just a couple of weeks.
Yeah, that's fine.
Okay, we'll reset him 2 weeks, and we'll need an announcement
Yes,
for sure
ma'am.
at that time. Thanks. And then you have Sharita Washington.
Yes, ready on her.
Did you do?
It's going to be relapse IP. I don't know if we needed to do paperwork on it. Do we need to do it?
I don't know. Is there? Let me look at it real quick, and then we'll. Good morning. You're Sharita Washington?
Yes, ma'am.
Give me just a second. Good morning. Good morning, Ms. Malfino. Good, thank you. Let's see. Okay.
On behalf of the state of Ohio, Ms. Tranter.
Your Honor, it's my understanding Ms. Hose is going to be changing her plea this morning to count 1 of the indictment, felony of the forgery, felony of the 5th degree. State will ask for dismissal of count 2.
Mr. Swift, is that accurate?
That's correct, Your Honor.
Ms. Hose, you're telling me you're going to change your plea to 1 count of the indictment. Before I get you to change the plea, I am required to go over some things with you, okay?
Yes, sir.
How old are you?
I am 33 years old.
How far did you go in school?
I got to the 9th grade.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Swift?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document called a change of plea. On the 3rd page of this document, on the line marked defendant, there was a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
We went over it, but yes. Yes, sir.
Do you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to 1 count of forgery as a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Do you understand the maximum penalty?
Yes.
In addition to the maximum penalty, you're also subject to a discretionary period of post-release control, which means if you are sent to prison upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison by the adult parole authority for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you get sentenced to. Do you understand that?
Yes, sir.
It's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, or what some refer to as probation. If placed on community control, you will also have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir, I do.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir, I do.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. If you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes, sir.
Ms. Tranter?
Your Honor, in addition to the facts alleged in the indictment, this offense occurred November the 17th of 2022, Warren County, state of Ohio. On that date, the defendant, Ms. Hosa, did attempt to make a withdrawal from the victim's Fifth Third bank account using a fraudulent withdrawal slip and a stolen identification card.
Mr. Swift, anything on those facts?
Nothing.
Ms. Hosa, did you hear the statement that was read?
Yes, sir.
Do you admit and acknowledge what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, those rights we discussed?
Yes, sir.
What is your plea?
Guilty.
Court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty. And based upon the statement of facts in your plea, the court will make a finding of guilty. I'm going to order a pre-sentence investigation, Ms. Hose. We'll come back in a few weeks and do sentencing at that time.
Your Honor, can we be heard on the bond?
Sure.
I think Ms. Hose has some extenuating circumstances going on with her right now. I'll let her explain to the court why she didn't show up last April, what her current situation is, and she also just had a 2-month-old child. So why you didn't show up first?
Okay, first, why I didn't show up. I had I lost my job. I lost everything. So I didn't have no means of transportation. So that was why I didn't show. That's why I wasn't able to show up. That has changed. I do receive Social Security. I receive $943 a month. I recently just received one of my checks. I get paid the 25th of every month. And what else was it?
Working in your housing.
Oh yes, I was. I was approved for housing. So right now I am supposed to be looking for housing, a 2-bedroom for the daughter, my 2-month-old daughter. I am currently fighting for custody for her in Hamilton County in court. I was also last year before, I tested positive for HIV. And I do have mental health issues, which I'm not receiving proper medication for because the jail does not give those medications. And also my vital loads have to be checked every month. I have doctors with homes in Oxford. And as I said, I do have means to show up to court. I will be at court. I can't afford bond, but I can afford to come to court. I can pay for transportation. I can do that, but I don't want them to take permanent custody. Right now, I've been granted visitation 10:30 to 2:30 every Friday. I have my CPS worker's number. She let me know that if I were to get out today, then I can go see my daughter Friday. I haven't seen her in like 3 weeks because of other situations with the temporary foster family. But I promise you, sir, on my ancestors' eyes, that I will be here.
So this isn't a situation that you just last week or last month or even a few months ago that you didn't show up. It's been 1 year and 4 months that you've been gone. You're telling me you didn't have access to a phone to call somebody up here?
I did. I called that probation officer at the time.
Did you think that this was just going to magically disappear?
No, sir.
Okay.
No, sir. Not.
Look, first off, I'm not going to grant you a bond after having absconded for 1 year and 4 months from 5 months from your previous bond order. Second is there's no victim hasn't been notified of this today, so the request is denied. All right, that's all.
This is still.
You're going to be held in the county jail pending your sentencing. I'll reconsider if Mr. Swift wants to file another motion and notify the victim in the case. I'll reconsider it, but at this point in time, you're going to sit in jail. That's all.
Thank you, Your Honor.
So she was ordered a safe P already. Does she go and
She was unsuccessfully discharged from the aftercare, the Melton. She left the Melton Center.
So the agreement is to go back to for relapse? Does it need to be is there a special needs relapse?
Yes,
Okay.
special needs. It's got a lot of.
Sure. Ms. Washington, the best you can, raise your right hand for me, please. Do you swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, and will she waive the formal reading of the motion?
Yes, Your Honor.
Ms. Washington, in cause number 23, DCCR 1036, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 10th of 2024 for harassment of a public servant, and that was a 2-year deferred probation. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you failed to report as directed to the probation department June 2nd of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to enroll in services at the Spindletop Center. Is that true or not true?
I didn't tell you nothing about the inmates and more services, but I can do it though.
Okay, so we'll do not true for 2. Count 3 alleges that you're behind in your court assessed fees.
Yes,
Is
ma'am.
that true or not
Yes,
true?
ma'am. True.
True. And then count 4 alleges that you failed to successfully complete the safety program, including the aftercare. Is that true?
Yes, that's true.
Okay. Did you enter your plea to true to counts 1, 3, and 4 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
So it's my understanding, Ms. Washington, that probation feels like you still deserve a chance and that you have the ability to take advantage of some services and be successful. I want to make sure you understand from my standpoint. I have no doubt that they have let you know about everything, okay? From the very beginning with regard to SafeP, with regard to any special services through Spindletop. If you don't take advantage of this opportunity this time, and you're back in here because you didn't go and receive services or you don't successfully complete the relapse program at SafeP, we're not going to be talking about keeping you on probation. You understand? You could go to prison for 10 years today for violating your probation. It's that serious. So you need to make sure you take advantage of everything they have to offer you, okay? All right. So
Should the court consider maybe extending?
I'm going to have to, yeah, for sure. It's going to be extended, I would think, by at least 2 years. I'm going to make your probation go longer because you got to go back through SafeP now. So it's going to take longer. So you're going to have to prove that you can be successful. So I'm going to extend your probation.
Okay.
Hold on just a second. So here's another thing that's very important. Your behavior in the jail is something that I find out about. Okay, I get incident reports, and hang on, and it explains every time you get an incident report, every time you're calling a correctional officer the B word, every time. Hang on. Well, and I understand that there might be some issues. Okay. But I want to make sure that you do the best you can to follow all of the rules and not be disrespectful to anybody that's in there just doing their job and trying to help, right? They're just going to work every day.
Yeah.
Okay, they don't deserve to be treated that way. That includes when you're in SafeP. Because if you get to SafeP and you're on your medicines and everything's correct and you're acting like this, then you're going to end up getting revoked before you ever get out. Does that make sense?
Yes, ma'am.
Okay. So I'm going to find that you entered your pleas of true to counts 1, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow this agreement and I'm going to extend your probation for 2 years. And I'm going to order that you enter and successfully complete the special needs relapse safety program. Obviously, when you get out, you will be required to go to the Spindletop Center, be evaluated, follow through with any recommendations they have of treatment or medication or whatever it is. And all of that is so that you are successful. Okay?
Okay.
All right. Good luck to you, ma'am. You can go back with the bailiff.
Have a nice day.
Thank you, ma'am. You too. And then Ms. Holmes, you have Jamal Caddy.
Yes, Your Honor. They're gonna do a bailiff's call on this.
Okay.
Jamil.
Okay.
She's not gonna show me.
She's done. Okay. Well,
Things to do.
well, that's, what can you do? Good morning. Are you Jamel Caddy? And this is 25 DCCR 0177. Mr. Smith, it's my understanding the state needs to do a bailiff's call.
Yes, Judge. Cherie Drake.
Cherie Drake.
No response.
Your Honor, based on my client's books and records, the current rent to retain is $927 and costs are $206 for a total of $1,133 even.
We paid the late fee. Okay, we have paid the late fee already. So just let them do it.
The late fee for September would not be included yet.
Okay.
Thank you, sir.
Okay, so, all right. So.
We paid $250.
So with that amount, 1,133,
I have a receipt for a late fee of $250 that we gave to Heather. So I shouldn't be charged another late fee. No, it's a court fee.
There's a court.
206 is the court fee for it involved in filing this case. They are showing payments. They're showing an August payment of $69 on August 1st. I will check and see if I have. Here's other ledger.
Okay, and I may have confused it with a court.
No, sir, I didn't pay my rent until after the 15th.
Understood.
And then we received a check and we paid our rent.
All right, I have, sir, I have an updated ledger. I'm checking that right now.
Okay, thank you, sir.
Okay. Hang on just a moment.
Paid everything but $5 and the court cost.
Well, no, and then September's rent came due.
Yes, that's what Heather came and told us.
So you paid $878 in August, on August 19th. That took you to a $255 balance, and the rest is September's rent.
And we paid that $250. We were only $5 short.
When did you pay? When did you pay that?
I paid that last month. Yes, like the 27th or 28th.
We paid the $250 yesterday.
And we paid the $250, I think, Thursday.
Well, if you paid it, okay. If you paid it right, if you paid the $250 right before the weekend, it would not have been credited yet. We wouldn't have that because our office was closed for the holiday.
So,
explain what was going on,
sir. They are caught up until September's. I have an updated ledger right here.
Okay, and what are you showing that is owed?
Include September's with it?
Yes.
Okay. They owe right now $883.
883 plus the cost of 206? Or is 883 what they owe total?
That's what they owe total.
Okay.
Thanks, Caitlin.
All right. So therefore, it would be 883, cost would be 206, and the rent to retain would be 677, and 206 would be 883.
Okay, so that everybody's looking at the same. See, Mr. Lehman's telling me it's $883 total.
Correct.
Okay. Does Mr. Ware or Ms. Bradshaw anything else want to tell me?
No. Thank you for your time.
Does that cover it? Does that cover everything for you?
Yes, sir. So
Okay.
what is the total we owe? 883.
Yeah.
883. Okay, thank you.
You're welcome.
Okay. All right, Mr. Lehman, we can
Have a good
enter
one.
judgment for that amount and by I guess the 12th is what we're doing.
Thank you, Your Honor.
All right. All right. You two are all set. Thank you. Thank you. And how about Meadowbrook versus Shelby Wasaki, Pamela Ogle, and Troy Ogle?
Yes, I'm here.
Hi, and I'm sorry.
I'm Shelby.
You're Shelby. Okay.
Yes, and then Troy Ogle is my husband, and he is on as well. He is at work, so I'm not sure if he can unmute it. My mother-in-law, she is out of state. We did not get the court papers in time, so she was not aware, and I'm unable to get a hold of her.
Okay.
Here.
With Shelby, are you applying for financial assistance, some sort?
No, sir. So everything is paid up. The only thing that we owe is going to be September's, and then obviously the 205 court fee, and we will have that by the 5th of September and the 12th of September. My husband's the only one who works, and he gets paid weekly, but he makes the payments the first of the month, like the first Friday of the month, and then the second Friday of the month, which Heather and Caitlin both know that. But unfortunately, corporate files us, and then we fall into this position. But by October 1st, we will have the full amount on the 1st. So we won't have to worry about paying the second week as well.
Yeah, so you don't get caught like that. Okay. Mr. Landman.
Your Honor, based on my client's books and records, rent to retain is $1,000 even. Costs are $244 with 3 tenants for a total of $1,244.
So it's not the 1,256 because my rent payment alone is $1,000, and then it would be 206, but there would be a $50 late fee.
The $50 late fee kicks in after the 5th.
Okay.
Court fees are $244, not $206, because there are 3 of you rather than 2.
Okay, so then the total amount altogether again, please.
Right now is $1,244, but after the 5th, it would be $1,294. But we're not at the 5th yet.
Okay.
Sounds like Ms. Wasaki understands that and agrees that those are the figures. Ma'am, is that right? Does it make sense? Ms. Wasaki, you still there?
Yes, can you hear me?
Yep, I can.
Okay, I said yes, sorry.
Okay, no, that's okay. You got a little bit of distraction with the child there, it sounds like. So, Mr. Lehman, I think we're all set. We can enter judgment Lowy right after the 12th.
And it would be a default as to Pamela Ogle and after hearing as to the others.
Yeah, but the same, yeah. And Ms. Wasaki, just for your sake, it'll be default to them, but it'll be the same figures, okay?
Okay.
Okay, and it looks like you're all set.
No, I have a couple more.
No. Oh, yeah, no, I'm talking about her.
Oh, yeah, her.
Yeah.
Okay,
Yeah.
thank you.
You're welcome, ma'am. Right. Let's see, I've got Meadowbrook versus David and Virginia Zietz.
And they are present, Your Honor.
Okay. Zietz. Just need you to unmute for me.
There we go.
There
Can
you
hear
go.
me?
Right. Yep. They have David and Virginia.
Yes.
Zietz. Okay. Do either one of you want to talk to legal services?
No.
No. Are you applying for rental assistance?
No.
No. Just want to proceed?
Yep.
Okay. Mr. Lehman?
Your Honor, my client is showing rent to retain of $2,295.06. Additional costs of $37.46.50 for replacement of the air conditioning system. $206 in costs for a grand total of $62.47.56.
Zietz or Virginia Zietz, anything you want to tell me?
Yeah. They replaced the central air unit here. That was not our fault that it broke. They're saying that our dogs peed on it. They did not. They can't even reach it. So I don't see how we can get charged for that. I have no problems catching up on the rent itself, but I don't see how I'm responsible for a central air unit. We are renters. We're not owners.
Your Honor, under the terms of the lease, they would be responsible for damage that was caused under their watch. They tied their dog up right next to the AC unit. It is our position that the dog did urinate on the unit repeatedly and destroyed it. And that is what the heating and cooling company is claiming as well. If there's not an agreement, then I think you'll have to schedule this for a second hearing or in fact a trial.
Yeah, okay. All right.
Our dogs never reached the unit.
Okay.
So I don't get where they're coming up with that. Here's my wife right here.
When the AC unit was installed, it was installed 2 foot from the back steps of our porch. I then had to have my porch turned facing out the other way so that my dogs could not reach it. But it was not destroyed. It was originally a line was broken in the AC unit because they failed to level the trailer. They had someone else come out, level the trailer. After it was leveled, then the AC quit working. That was 2 months after it was installed.
Okay. All right. I guess Mr. Landman, let's just, I guess we can leave that. But how much, just out of curiosity, how much is the I guess the repair bill for it?
The AC, the bill for the replacement of the AC unit, Your Honor, was $3,746.
So it's a significant.
It is sizable, yes.
Yeah. Okay. All right. Let's just. I can either. I don't know if it's helpful if I just adjourn it for.
I think adjourning it for a week, Your Honor, really doesn't take us anywhere. If we could simply get a trial date, that would be wonderful.
Yeah. And the two of you don't want to speak with legal services?
Yeah, we do.
That's what I wondered. And that things were going to change. So let's
because they literally put the biggest AC unit in that they could put in. None of the other trailers in this trailer park have an AC unit that big. It's like for a house.
Okay, so don't tell me anymore. We'll just adjourn this matter to I'm sorry, Mr. Landman, next week, September 9th.
Yeah, I think that would give legal aid a chance to get caught up to speed if they're going to get involved.
Sure. We'll adjourn to September 9th at 9:30, and I'm going to give both of you the telephone number for them, okay?
All right, hold on 1 second.
Okay.
All right, you're good.
810-234 2621.
2621.
Okay, and make sure you call them as soon as we get off here, okay? That'll get you at least getting something started for you, okay?
All right, thank you.
All right, guys. We'll see you next week. Dan, tell them you got a date next week, just so they know that too, okay?
You said September 9th?
Yep, September 9th at same time, 9:30.
All right, thank
Then,
you.
Your Honor, the only other case I have is Meadowbrook versus Christina Franklin.
Yeah, and I'm out of files or something. Oh, these are dismissals. See if I can.
348.
Hey, I do have I got a yep, I got a file and it's got a dismissal on it. Oh, no, that's not,
see.
no, that's not that one.
No, her case should still be going forward.
Yep, they just stuck the dismissal on something else here. I do have the file though. Meadowbrook versus Christina Franklin.
And Daniel Landman for the plaintiff.
Okay. Christina Franklin, anybody? Nobody responding. Looks like I got, let's see, 487. Looks like nobody on our Zoom meeting. Do you have personal service plus court mailing? We can proceed.
Thank you, Your Honor. Based on my client's books and records, Your Honor, the current rent to retain is $1,375. Costs are $168 for a total of $1,543 even.
Very good. We'll enter a default judgment.
Thank you, Your Honor. And that covers everything for me. Have a great rest of the day.
Yeah, you too. Thank you. And Meadowbrook, thank you.
Thank you.
All right, bye now. No, that's right. Right there. Oh, yes. Let's see, Karen Morrow, are you there still?
Yes.
Ms. Morrow, I'm kind of not doing you much good right now. I'm trying to move you up a little bit. Well, but we do have Karen Morrow versus Robert Brewer and Amanda Blakely.
I've been on here since 9 o'clock.
Yeah, I know. I gotta take them in order though. Do I have Robert Brewer or Amanda Blakely? Anybody? Nobody responding. I do have personal services. Just make sure I get. Oh, Robert Brewer.
I see their names, but I don't. They got their speaker muted.
Yeah, let me see if I can get them here. Amanda Blakely or Robert Brewer. Mr. Brewer, are you there?
Yes, I'm a fixed speaker.
Okay, and do I have Amanda Blakely too? She must be
right here next to me.
Oh, okay. So let's just leave it on the one then. Do either one of you want to speak with legal services?
Yes, and we would like to get a jury trial.
Okay, well let's speak with legal services first, okay? And if you're gonna want a jury trial, you're gonna pay the jury fee or get it waived, okay? So but talk to legal service. We'll adjourn this matter to next week, September 9th at 9:30. And I'm gonna give you their phone number again, okay?
Okay, thank you, Your Honor.
Sure, it's 810 234
okay
2621. And it is a termination case, so we'll make sure you tell them it's a termination case.
Termination case?
Yeah, it looks like Ms. Morrow was it, I guess for both your sakes, may I help you just a little bit? Ms. Morrow, was there a lease agreement?
No, no.
Oh, no.
They lived here for over 3 years. They don't pay rent. They're destroying my house. The yard's junk.
Yeah, don't tell me a lot. I just want to try to get a feel for what you got. So there's no lease agreement. There's been no rent. It's a termination case, Mr. Brewer. So we'll deal with it, quite frankly, probably next week. But call legal services, okay?
All right, thank you.
All right, you're welcome. Ms. Morrow, I'm sorry. Does that date work for you?
Well, I have eye surgery on the 10th, as long as I can.
I'm sorry, you what?
I have another eye surgery on the 10th. You said the 9th?
Yeah, the 9th. Yeah.
Okay.
So we'll leave it on for the 9th. Hopefully we can just get it done by then, okay?
All right,
everybody.
thank you.
All right, you're welcome. You're welcome. Bye.
Thank you.
Oh, you're welcome.
Thank you.
You're welcome. Let's see. Maybe the bike please off of there too. And gosh, Mr. Sabo.
Your Honor?
Yep.
I'm only on here. I sent an email to your office that we're dismissing that motion. And
I wonder, I just left it on for next week just because I didn't hear from you.
And Your Honor, we received an odd response that said that we needed to pay a motion fee, and we tried to indicate that we already have a motion up and we just want to dismiss it. So I just want to put on the record that I will have a stipulated order of dismissal into you today. Is that okay?
Yeah, that's fine. It's I'm sorry, dismissal on just the motion. Is that what it is?
I believe that's the last item of the case.
Oh, that works.
I believe that disposes of the case. So,
okay.
What I'm going to do, we had email correspondence, so I'm getting a stipulated order of dismissal over to opposing counsel.
Just do that, and I'll make a note. I don't know what. I'll talk to him and see what's going on.
Yeah, I think we're finally done with this, so you're good.
Good.
I appreciate your patience in this matter. It was a little bit of a taxing with all the parties involved.
Well, I'm glad it's quite frankly done. That's all.
Yeah, exactly. Yeah. Thank you very much. You have a great one.
You too. Bye now. Bye. Yeah, let's see. Meadowbrook versus, actually it's a dismissal, versus Dwayne Kiesling and Warden.
Yes, I'm here.
That matter is being dismissed.
Yes. So I paid all of August and the court fee already. It was a couple weeks ago. I don't remember the exact date. And then we are paying all of September's rent on, I believe it's the 5th. It's this Friday.
Okay. Well, either way, don't tell me too much because they're just requesting I dismiss it anyway. So don't tell me too much. I want to make a record and we're going to make it something else come up. Okay.
Okay. Thank you.
Yeah, you're welcome. So I've just signed it literally right now while we're talking for you. Okay.
Okay. Thank you so much.
All right. You're welcome. Bye now.
Bye-bye.
That becomes a lesser offense, Your Honor, simply by deleting the second sentence in count 1, the operation of the motor vehicle language. Ms. Cook is expected to also enter guilty pleas to counts 2 and 3 of the indictment. Those are endangering children counts with separate victims for each count. Those are misdemeanors of the 1st degree. If those pleas are forthcoming, Your Honor, the state would ask that the court conduct a pre-sentence report prior to any sentencing determination. Thank you, Your Honor.
Thank you. Mr. Watson.
Thank you, Your Honor. May it please the court, that's my understanding of this morning's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. I've also had ample opportunity to discuss this matter with Ms. Cook. She has indicated to me that she is prepared to enter a change of plea as just outlined by the prosecutor. She understands that by entering a change of plea, she'll be waiving certain constitutional rights, and no threats or promises have been made in order for her to do so, Your Honor.
All right, thank you. Ms. Cook, how old are you?
26.
How far did you go through school?
High school diploma.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
Yes.
What have you been diagnosed with?
Schizophrenia, bipolar depression, ADHD.
Are you being treated for any of those conditions?
Yes.
And what does your treatment consist of?
Medicine, but I'm not taking the medicine. I got to go back to the doctor in a couple of weeks because it made me sleepy and drowsy where I won't even get up for the day.
Do any of those conditions affect your ability to understand what's going on here today?
No.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you some questions. If you don't understand the question or you want to talk to Mr. Watson some more, let me know and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order that's called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to these charges?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
You understand by pleading guilty to the felony in count one that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
The lesser included offense in count one, failure to comply with the order or signal of a police officer, is a felony 4. It carries a maximum prison sentence of 18 months and a maximum fine of $5,000. Do you understand that?
Yes.
Both counts 2 and 3 are child endangerings, both misdemeanors of the first degree. Each separately carries a 180-day maximum jail sentence and a $1,000 maximum fine. Do you understand that?
Yes.
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, the maximum prison sentence you face is 18 months and the maximum fine would be $7,000. Do you understand that?
Yes.
Do you understand that your conviction on count 1, there's a mandatory driver's license suspension of at least 3 years up to your lifetime? Do you understand that?
Yes.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and you violate any conditions, the parole authority could return you to prison for up to 9 months for each of your violations, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
And if that were to happen, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Yes.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Watson before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
Ms. Blake, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had the matter proceeded to trial, the state would have proven beyond a reasonable doubt that on March 2nd of this year, 2025, Eastlake officer Jacob Reich was patrolling the area of Vine Street in Eastlake, Lake County, Ohio, near Town Laundromat. In running registration checks, he realized that the registered owner of a dark blue Audi bearing the license plate KWAM31, Brianna C. Cook, did not have a valid driver's license. When the Audi left the parking lot, Officer Reich was able to make a visual observation that the driver was in fact Brianna Cook. He attempted to effectuate a stop of the vehicle at the intersection of State Route 91 and Curtis Boulevard, but the defendant continued to drive without stopping. She proceeded to enter State Route 2 in a westbound direction. She did reach speeds of 70 or more on the entrance ramp and then greater there once she entered Route 2 and did pass traffic in the right or on the right berm. Officer Wright did follow the defendant until the 305 exit, which is the next exit westbound, but did not give further pursuit. In reviewing the footage from Town Laundromat, it was later learned that Miss Cook was a customer at the laundromat that day, and she exited the laundromat with her 2 children. I'll identify them for purposes of the record by their initials, 8-year-old RO and 10-year-old MC. They entered her vehicle with her, and they were present in the back seat of the Audi when Miss Cook fled from Officer Wright. The state would have proven that recklessly created a substantial risk to their safety and or health. Had this matter gone to trial, Your Honor, that is what the state of Ohio would have proven. Thank you.
Mr. Watson, anything to add to those facts?
No, Your Honor.
Ms. Cook, did you hear what Ms. Blake said that the facts would show if the case went to a trial?
Yes.
Are those facts true?
Yes.
What is your plea to the lesser included offense in count 1, failure to comply, a felony 4?
I plead guilty.
What is your plea to count 2, child endangering, a misdemeanor 1?
I plead guilty.
And what is your plea to count 3, child endangering, a misdemeanor 1?
I plead guilty.
All right, Mr. Watson.
This is the same form, okay? So we just wrote in there that you are a citizen of the United States. You do not face mandatory time, and you are allowed to apply for judicial release. So you should sign right there. And today's 9/2/25.
Just for the record, I have witnessed Ms. Cook and her attorney, Mr. Watson, review and sign the written plea of guilty and judgment entry. I'm now signing it as well. With the court's permission, I can return it to the bench.
Ms. Cook, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
Accept the written plea of guilty. Defendant was present with Mr. Watson, advised of all of her rights, made a knowing, intelligent, voluntary waiver. She understands the nature of the charge, consequence of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept her plea of guilty and find her guilty of the lesser included offense in count 1, failure to comply, of felony 4, and counts 2 and 3, both endangering children, both misdemeanors 1. I'll refer this for a pre-sentence report and a psychological evaluation. Sentencing will be October 15 at 1:30 p.m. and the bond is continued. Anything else, Ms. Blake?
No, Your Honor, thank you.
Mr. Watson?
Nothing further, Your Honor.
I just take the plea, get this on with. If I get out of here.
Your Honor, with the court entertaining a no contest plea.
I can. If the officer told you that they pulled you over on that date, would you have any issue with that date? With any objection to that?
Yeah.
You don't have any objection to that? All right. As for SP 1478556, one and counts 2. I'm going to enter a no contest plea to the amended counts of improper plate for both counts. I'm not going to fine you for those.
Thank you, Judge.
Thank you,
With stipulation of probable cause, we'll dismiss the other matter.
So stipulated.
All right, I'm going to waive the warrant fees.
Thank you, Judge.
You owe some other matters down here, so the 240 is what I'm concerned about. When can you pay the 240?
What's that ticket that's on?
That failure to display, you just pled guilty to.
I need at least about 35 days, shot.
We'll give you 30 days. 30 days to either pay it or get into a payment plan.
Okay, I can do that.
You don't have to come back here. If you don't pay it, just go to warrants going to be put out for your arrest. 2025, I'm marking the file allow. Payment plan, you can pay it at any div that kiosk in the city of Detroit. I'm told you're going to upload the div that app to your phone, or you can come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it.
Okay.
And then, Judge, in order to get on a payment plan, Mr. Gist would have to physically bring $60 to the court, correct?
I don't know. I thought it was 20%. Maybe they changed it because I can see the other cases have not put up to 20%. But you have to go downstairs. They can get some information on how you get into that payment plan. All right.
But look, how long do I got to pay that 240? How long do I have? Can you just give me a flat out time to pay the 240?
October 6th.
October 6th. All right, I get that. I get it down.
October 6th. All right. You're trying to get a valid license, you need to pay that insurance.
Yeah, October 6th.
October 6th. If there's nothing further, have a very good day. Best of luck to you.
All right, thank you, Your Honor.
Thank you. Thank you, Judge.
Do you want to document the paperwork?
Do you want to wait for your paperwork, sir? Yes, just wait in the hallway.
Your Honor, just want to.
Yes.
Officer Nari Mitchell checking.
Nari Mitchell? I don't believe I've seen an Officer Mitchell.
Okay, we have retained counsel. I'm gonna grab him. He's gonna make a motion. And that's for first trial.
Andor, right?
Jackson.
Yeah, I don't have Officer Mitchell on my.
And I didn't speak to him there.
He's not on this one either. All right, I don't see it.
Okay, thank you, Your Honor. I'll grab retained.
All right. Who are we ready on? You need someone, right? This Gun Gowdy.
Yes.
Good morning to you, ma'am.
Good morning.
Is it Janisha Dowdy?
Yes, sir.
City of Detroit versus Janisha Dowdy. Case number is SP 17-071361, SP 17-103901. Appearance for the record, please.
Kathy Murphy, P51422 for Ms. Gowdy. Ma'am, would you please state your name for the record?
First name Janisha, last name Gowdy.
Judge, this is a pretrial. I thought it was a show cause. Okay.
Pre-trial, Ms. Gowdy, she has a speeding ticket that was this year. I wouldn't have any objection to setting that default aside if the city does not have any objection to doing so. The other matters are in default, and they were last year, so we're going to vote as they are. And she has I don't have any objection to the improper U-turn as well. That's in default. Improper U-turn in a 6 to 10, see if the city will allow her to be heard. If they have any objection to her being heard on that. Ms. Gowdy, I'm going to put you in a breakout room with Ms. Murphy. Ms. Murphy, she's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay?
Okay.
Room, let us know what you want to do when you come out.
So you put down for Gordon Griffin, correct?
Say that again.
You have Gordon Griffin's $5 offer from the
Gordon Griffin, I do. I thought I asked for it. Was that Janisha Gowdy?
Yes.
Janisha Gowdy. All right, who are we? Mr. Berry, Ms. Harris. All right, we're waiting on a lawyer. Any lawyers ready? Mr. Ogletree? All right, we're waiting on a lawyer. Have you got on yet?
He's on.
He's on? I don't see it.
But he's on as you.
I don't see him.
The lawyer left.
Mr. Law, please do not interrupt, all right?
Okay.
Everybody, we're just waiting on a lawyer, all right? Okay, I see. What kind of documentation does he have?
Yes.
Officer Wilson, what kind of documentation is he trying to?
Let me ask the judge.
Your Honor, I was still in the break room. Just letting you know.
It's just you're just gonna keep on doing that.
Nah,
I don't need for you to come out of the break room, okay? When your attorney is ready, the attorney's gonna come in there and see you.
No problem.
Mr. Ogletree. And Officer Rios, I think your case, who are you on, Officer Sergeant Rios?
First initial K, last name Laria.
Okay, they're here, their attorney is here. Okay. All right, give me a few minutes. Miguel Ortiz, he never unmuted himself. All right, we're just waiting on a lawyer now. Counselor, you ready on Zandor?
Ready, Your Honor.
All right, let's call. Okay. City of Detroit versus Zandor, Liddell Gatson, case number SP 172222191. Appearance for the record, please stand over by the microphone there.
Oh, okay, Judge. I'm so good.
Yeah.
Good morning, Your Honor. I'm Jim Washington. P42503. My client, Mr. Zandor Gatson, is to my right today. is the date and time set for trial, Your Honor. My client is prepared to proceed and understand that the people are not, and we're therefore going to ask the court for dismissal of the matter.
All right, Mr. Gatson, good morning. You state your name for the record, please.
Sandor Liddell Gatson.
All right, day and time set for a trial. The counsel came in and asked whether Officer Mitchell had appeared. I don't see an Officer Mitchell on my list. Officer Mitchell. Hearing no response, go ahead, counsel.
I would motion the court for a dismissal.
Oh, case dismissed. If there's nothing further, have a very good day. Best of luck to you both.
Thank you, Judge. Thank you, Judge.
I thought it was going on paperwork and every process. But I'm sorry. You said Lopez. Romeo Lopez. No, it's just still up there. Oh, okay, just see if he needs it. If you need it. Okay, I'll process it for you. Give me a second.
See if I can get rid of some people. Who had Patrick Rapp? He's gone. He's gone. Run Mr. Locke's license, please. That Emmett Long does. I call it. The city of Detroit versus Kayla Lewis, case number SP 159-25761. Good morning, Ms. Lewis. State your name for the record, please.
Good morning.
State your name for the record, Ms. Lewis. Turn your camera on, please. Today is the date and time set for a review. Let me see the Kayla Lewis for review. I see that you paid. I want to see what the disposition was supposed to be.
Okay.
Dismiss the case, ma'am. If there's nothing further, have a very good day. Best of luck to you, okay?
Thank you.
Is Orlando Gilmer here? Asia Gray? I think Asia Gray is here, right? Okay, what about Lance, Curry Lance, or Antonio Oliver?
Excuse me, Your Honor, you said Swanee Lanza?
No, I didn't. Good morning to you. No. Just waiting on a lawyer now for. Brandon Love.
Yes, sir. Here I come.
What brings you here today? Brandon Love, not Dior,
not DeLorean Love.
Not DeLorean,
Okay.
not DeLorean. Brandon Love.
Oh, all right. Sorry, sir.
Brandon Anton Love.
Yes, this is Brandon Love.
Is that Brandon Anton Love?
Yes.
Okay, your name was not spelled correctly either. Why do you spell your name? Good morning to you.
Good morning, sir. Brandon.
Listed here is Bradon. Date of birth?
2/27/89.
Who's on that, I never got the name of that, Motors Roar Mouths Talk. Who's on that device? Are we ready on anybody?
Ready as to Mr. Ortiz, Your Honor.
Let's go back on the record for Mr. Ortiz. Mr. Ortiz, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client would avail himself of the people's offer to allow him to enter a plea to the open alcohol in a vehicle as a passenger. The seatbelt matter to be dismissed.
You want to take the deal, sir?
Yes, sir.
All right, raise your right hand, please. You swear or affirm to tell the truth, whole truth, nothing but the truth?
I swear.
You can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fine?
Yes, Your Honor.
You understand you have an absolute right to a trial?
Yes.
Mr. Berry went over your other advice or rights on breakout room, did he not? Did Mr. Berry go over your other advice or rights in the breakout room?
Oh, yes, Your Honor.
And you understood those rights?
Yes, I did, Your Honor.
Questions about those rights?
Nope.
You know by taking the deal, you're going to give those rights up?
Yes, I do.
Has anybody offered you anything other than what's been stated in the record?
No, sir.
Let me draw your attention back to April the 18th, 2025, around 5:55 p.m. in the city of Detroit, in the area of is that Southfield Service Drive and Joy Road. Did you have an occasion on that day to come encounter with the Detroit Police Department? Strike that. Did you have an occasion on that day to come encounter with the Michigan State Police?
Yes, Your Honor.
Were you in a motor vehicle, sir?
Yes, I was.
Did you have some alcohol in that motor vehicle?
Yes, I did.
Was the alcohol open?
Yes, it was, sir.
What kind of alcohol did you have?
I have a pint of brandy.
And it was in the passenger compartment of the vehicle, and it was open, correct?
Yes, Your Honor.
Find your client guilty of the amended count of open alcohol in the motor vehicle passenger. $240 will be the fine. I'll dismiss the other matter of stipulation of probable cause.
So stipulated, Your Honor.
$240, sir. When can you pay it?
In 2 weeks.
Two weeks from the day is get it in here by September 19th. September 19th. Pay it any div that kiosk in the city of Detroit. I'm told you can upload the div that after your phone, or you can come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it, Mr. Ortiz. If you don't have anything further, I wish you the best of luck. Have a very good rest of your day.
You as well. Thank you, Your Honor.
Dismiss. I'm sorry. All right, Mr. Gibson, are you there? Samuel Gibson?
He's in the hallway, Judge.
Yeah, he's in the hall. He should be on.
He just has to unmute his device.
I'll do it. I'll unmute the phone.
Did you ever give Samuel Gibson's phone?
Hello, Your Honor.
All right. City of Detroit versus Samuel McKinley Gibson. Case numbers SP 172-56331. 977-2230, counts 1 and counts 2. Appearance for the record, please.
That's Barry Jr. on behalf of the defendant. State your full name.
Samuel
Mr.
McKinley
Gibson.
Gibson.
All right, you have to speak up, Mr. Barry. Mr. Gibson has a little bit of difficulty hearing. Go ahead, Mr. Barry.
Your Honor, for purposes of arraignment, my client would stand mute.
We'll enter a not guilty plea on your client's behalf. We'll give your client a $0 bond. Mr. Barry, there's 2 other cases I called into the record that were civil infractions that are in default. I would have no issue with setting the defaults aside to allow Mr. Gibson to be heard on those. One is a no insurance proof. It's $336. I would have no issue with allowing him to pay the reinstatement fee up front, and the other was a prohibited left turn. Mr. Gibson, Mr. Barry's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay? I don't know which one he's on. Join the room, please. I hope I chose the right. You see a join button there? Join. Try the other one. See a join now? Do you see join, Mr. Gibson?
No, I don't, something is going wrong with my phone. I don't understand nothing going on.
Need to get back in the courtroom?
Yes, I'm
Where's
here.
the officer?
The court officer keeps on the hall and says, yes, it's paperwork.
Breakout room. They tell me to join the breakout.
Where's Officer Wilson?
He's coming back. He did have a replacement.
He's in there now, Mr. Barry.
Thank you, Your Honor.
I passed the matter. Let's go back on with Gordon Griffin. Mr. Griffin, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Recommendation to dismiss. There was no recollection by the officer.
Process replacement.
Oh, good morning. All right. Who was the officer?
I believe it was Hernandez was the last name.
Okay.
Mr. Gibson. Mr. Gibson, he's on the
I
judge's
believe
board.
she, Ms. Horn also placed a written recommendation in the file if you needed to see it.
Yeah, there's no recollection. Case dismissed. Mr. Griffin, have a very good day. Best of luck to you.
Thank you, you too.
You're welcome.
Is Mr. Gibson finished with your phone?
No, he's still on. He
He's
just
still
got
on
into the
it. Okay.
breakout.
He just got it.
He just confused me.
City of Detroit versus Emmett James People Long, case number SP 1696563, counts 1 and counts 2. Appearing for the records, please.
Yes, Your Honor.
Sherika Harris, on behalf of Mr. Long, please state your name.
Emmett Peoples Long.
Good morning to you. Day is the date and time set for
Pre-trial.
pre-trial. Thank you. Give Mr. Long an updated offer. Keep in mind, Mr. Long, if you don't like the offer, you have an absolute right to a trial. I'll put you in a breakout room, Mr. Harris. Let us know what you want to do when you come out, all right?
Yes, Judge.
Join the room, please. Let's pass the matter. Reed, are you ready on your client?
Yeah, I've been waiting. She's been in and out, kind of. We haven't spoken.
All right, before city attorney's here, she sees you're here, Ms. Reed. Mr. Barry.
Your Honor, I'm going to ask for an adjournment if possible. My client had to go to work at 11.
11.
Yes, and she said there's no service in her building. And the city attorney, I was there in the waiting room for quite some time. She was handling other matters that were in her physical office. So I don't want my client to get in trouble at work.
Yeah, I understand. I've been looking for you though, even before you were in the breakout room. I didn't see you in the courtroom.
No, I was in Frank Murphy. I wasn't in that courthouse.
Right.
Bring her back on Thursday and tell your officer, Sergeant Rios, are you available Thursday?
Thank you, Your Honor.
Ms. Reed, are you available Thursday?
Yes, Thursday is great. And may I I'm going to put my email in the chat for the city attorney if she can just email me over the offer at her convenience.
Okay, no problem.
I'm sorry, Sergeant Rios, I am available on Thursday also.
All right, let's go back on the record with Ms. Loria. Ms. Loria, are you out of the breakout room? Are you there, Ms. Loria?
Being issued for his arrest, as well as the defendant did violate general condition number 5, in which on February 10th of 2023 and March 2nd of 2023, the defendant failed to report to his Kentucky ICOT supervisor as ordered.
Mr. Feldman, do you understand the allegation?
I do, Your Honor.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
I do not.
You may appoint you one?
No, if we could we just go through with everything today, Your Honor? I didn't know that I missed those. Those are my last 2 dates. I was on where you just fill out a paper or drop it off at the podium for the probation. I'd walked down 3 years.
You what?
I walked down the 3 years of probation that you originally gave me.
I'm not following what you're saying.
So it said I didn't report.
Yeah.
Apparently it was my fault, sir. Apparently I got everything confused.
Mr. Feldman, you have 18 months hanging over your head. You've served a total of 75 days so far. Sure you want to talk to an attorney? Was restitution ever paid?
It was, Your Honor. It was actually paid by his fiance when he was incarcerated on the warrant.
This time after he was arrested?
Yes.
So he really didn't do anything that he was ordered to do
No, Your Honor.
before he was picked up. Well, it's your call. If you want to waive your rights to an attorney, then I'll let you do that, but.
May I say something?
Sure.
One of the things I have done is I have stayed sober through everything. I've got 3.5 years sobriety. I have a job. I've got my language, my stuff together. It was hard figuring out once I got sober how to continue on with life. That's why I was a little bit late, but I do have a good job. That I'm expected. I do live in Louisville, Kentucky, sir. I haven't been in any trouble. So that's all. That's all I have. That's all I wanted to say.
Any change to your recommendation?
No, Your Honor.
All right, if you want to waive counsel, Mr. Laux is going to hand you a form with a waiver of counsel that you need to sign. All right, is that your signature?
It is, sir.
Do you believe you understand what this document says?
I do.
Has anyone promised you anything or threatened you in any way to get you to waive your right to counsel?
No,
Are you under the influence today of any drugs or alcohol?
I am not.
All right. Court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your right to counsel. With regard to the allegation of you absconding, do you want to have a hearing or do you want to admit to the violation?
I'll admit to the violation, sir.
All right. The court's going to find that you have violated the terms of your community control. The court will order you to serve an additional 60 days in Warren County Jail and you'll be terminated. All right. That's all.
75. You told me I had no one. That's what I forgot.
This is case number 25CR42925, the state of Ohio versus Kevondre Walton. Mr. Walton is before the court. Mr. Guyman, who has been appointed on his previous case, pending case, is present in court.
Mr. Walton, you have been indicted again by the Warren County Grand Jury. Have you received a copy of the new indictment?
It's not, Judge.
All right. Mr. Laux has handed you a 2-page document. It is a 1-count indictment for felony 5, aggravated possession of drugs. Carries a maximum penalty of an additional 12 months in prison and a $2,500 fine. Do you wish to wait and waive the, do I wish to waive the 24-hour rule, or do you want me to reschedule the arraignment?
No, Judge, we would waive the 24-hour rule.
All right, the court will enter a plea of not guilty on behalf of Mr. Walton. We'll get discovery, you'll get discovery going, and we'll set this with the other case, the 42763, in about a week or so, okay?
Perfect.
Anything else?
No, it's not.
Anything else?
No, which you want bond? No bond, or, I mean, it doesn't
really matter.
It doesn't really matter.
So let's just show it as no R bond.
Oh, R bond.
On this case, but.
Okay.
All right, I'll see you in a week. Yeah.
Could we get a nominal bond just so he gets credit while he's sitting in there?
He's in prison. He's in prison on other charges. He's got 2 indictments pending here. He's not going to get credit on these cases.
Understood.
No matter what.
Okay.
Yeah, that's not going to happen. All right. Thanks, guys.
Thanks, Judge.
You want to sign that for me, Jeff? Thank you.
Park Ridge versus Tubbs.
James Sink for the plaintiff.
Come on up. Your name?
Sherry Tubbs.
All right. Ms. Tubbs, this is a termination case. And where are we on this case?
We still have, to our knowledge, an unauthorized occupant who's on the sex offender list residing in the unit. I checked the sex offender registry today. It still shows that Willie Gardner, also known as Mon Garner, or Gardner, is residing in the unit. And Your Honor, it's unauthorized occupant and it's a violation of the HUD rules.
For one, I never knew that he were on a sex offenders list, and I had no knowledge of any of his mail coming to my residence.
Why?
I didn't.
I mean, if mail comes to the house, wouldn't you see his name on it?
That's what I'm saying. I never received any mail to my apartment for Mr. Gardner. And I had no idea he was visiting until I found out about him being on the sex offenders.
My understanding, it's more than just visiting. He's using your address.
That's what I'm saying. I had no knowledge to that.
Let me just.
Okay. Okay.
When he's using your address, he's saying that that's where he is residing. Because that's what he has to report.
I was not aware of that. I told the office that too when they showed me the sex offenders papers when I went to talk with manager.
Your Honor, may I ask you a couple of questions?
Yes.
What, Ms. Tubbs, what's your relationship to Willie Gardner?
I used to be his girlfriend.
And is he still living at your house?
No, he is not.
And,
He's never lived there.
when's the last time he stayed there?
I'm not sure. Probably a couple months, maybe. Spent the night.
Months?
Yeah.
So
But
recently.
I have not, since I found out he was on the registry list, I have not. He have not.
Ma'am, so that you understand, here's the problem. If he's using that address and you have the relationship to him, the problem's going to be that you could potentially just be on the hook because that's a violation.
Okay.
And it may be the type of violation that can't be necessarily corrected because it's happened. Yes.
Well, so I had this great idea that we would do an inspection. No men's clothes there would mean that Mr. Gardner isn't staying there. But we think that two of Ms. Tubbs' adult sons are living there, even though it's a one-bedroom unit and they're not authorized occupants either. So just doing an inspection won't tell us anything.
Ma'am, do you still have communication with him at all?
I haven't in a while.
All right. Because that address has to change.
Okay.
And quite frankly, I'm going to go by whatever. It should have never been put there in the first place. But the fact that you had a relationship with him at the time that he did that is problematic from my standpoint, because there would have been mail at least coming from the state of Michigan to that address.
Okay.
So I'm going to set this for trial. It's going to be quick one way or another, because like I said, ma'am, the violation has already occurred. You need to find him, do whatever. That address needs to change. If that address is that address on the date of trial, I'm done.
Okay.
Your Honor, may I just point out for Ms. Tubbs that her sons are not allowed to live there either. That's not part of this case. We gave her a notice based on the sex offender registry, but there's been some problems and we cannot have unauthorized occupants. We cannot permit it.
You understand that, ma'am?
Okay,
It's not part of the case, but are they there?
No, my son, he has his own apartment.
Okay.
And my other son, he lives with his girlfriend.
They have any clothes there?
No.
Okay. Will you let somebody inspect your apartment?
Of course.
Okay. Make arrangements with Ms. Baylor? You don't?
I'd like that done today.
Mm-hmm.
Okay.
So I'll set non-jury trial on this matter for September 16th, 2025, 9 a.m.
Thank you.
All right. And
Okay.
so you better get to him, make sure that address is changed.
Okay, thank you.
Thank
Your
you.
Honor. Thank you.
New Park Ridge versus Kelly Hall.
Thank you to the plaintiff.
Hello.
Hello, Kelly Hall.
All right. And where are we on this case?
I wasn't contacting legal aid. My phone had ended up breaking. Okay.
All right, go ahead, man.
Okay, but Your Honor, I don't even wanna, like with this situation, I just need a little time to move. I got other legal things going on that I need
How
to
much?
take care
3
of.
days?
Please,
October 1st, 30th, we'll get a writ on the 1st.
Will that work?
yes,
September 30th? All right.
Yeah,
Thank
how about
you
if we
so
do a
much.
judgment that gets set aside if she surrenders possession?
Will that work for you, ma'am?
what do that mean?
That means there'll be a judgment in place that they can act upon, but if you vacate the premises by the date that you're supposed to vacate, they'll set aside the judgment, so you don't have. to.
Can I at least have until, October the 1st, please?
Looks like she can have
That's it.
until October 0.5, because I got one no and one yes. What's,
Mm,
The 1st is a Wednesday,
just
the 3rd.
Wednesday the 1st? So, Your Honor, we'll leave it at the 30th. We can't submit anything until the 1st.
Right.
And if she moves on the 1st, then we'll let the court know.
Thank you.
Works for you?
Yes, it
Hearing
does.
or consent?
By hearing,
Thank you so much.
not a problem. All right,
I need a copy of that or,
the judgment.
okay.
Okay, then you need a copy, so we'll sign off and then I'll send it down.
And Your Honor, I don't mean to make things worse for Ms. Hall or for anyone. This is a result of a series of disturbances. And given that she's going to be there another month, I'd just like to remind her that she needs to comply with the terms of the lease during this month.
Absolutely.
Thank you. Appreciate that.
Okay. And so so that you also understand, I'll take whatever action I need to take if they have to bring this back before me before the 30th.
That's right.
Understood?
Yes, sir.
Jen.
The judgment, there's also a sex offender registered at her place, which we'd like to be corrected before she vacates so that whoever moves in next doesn't have a sex offender tied to her address or his address.
His mail been stopped coming from there.
Well,
It's been stopped. That's why I'm going through what I'm going through right now.
Not part of our case, Your Honor, but
I know,
we want to try to get this cleared up.
I think
I'll talk to the DOC once she moves out.
Your Honor, I have a case against this man and everything, so.
Okay, but so here's the thing. The best way to handle it, quite frankly, is to contact the Michigan State Police. Let them know that he is not at that residence.
They know.
Well, no, but okay, don't do what I tell you to do.
I'm sorry.
Okay, I'm just saying, they don't want a problem with the new resident coming in. You don't want a problem where you're moving either.
Right.
Right?
Right.
So the best way to do it is to make sure you got it on that they are not residing there.
Okay. Okay. And the state you said, the state police?
Yes, the
Okay.
Michigan State Police.
Okay. Thank
Okay.
you so much.
All right, so I'm gonna sign off on this and then we're all set.
Thank you.
All right, so good luck to you.
Thank you so much. Have a blessed day.
You too. Court stands in recess.
Thank you. Saw you in relation to Joe Hall and Ken Hall and those halls.
Yeah.
After that, all the halls are related.
Where did she go?
He should be in the breakout room.
He's on the phone at 313-952-4573.
Miguel Ortiz.
Miguel Ortiz. All right, hold on. Yeah, I don't see Miss Lori. Tell her to come back let's go back on the record with Miss Lori. Come back on 9. What would that be? 4 at 8:30.
9/4, 8:30. Okay.
8:30.
9.
Lisa. Lisa, you out there?
Yeah, I'm here.
Well. Happy birthday.
Thank you.
Just happens to be a big one, too.
Yeah, it does.
Watching a show and somebody said, you know, when you reach 50, you're reasonably certain that your life is half over. So I'll just leave you with that thought as we go on.
Oh, well, thanks. I feel much better about it.
Happy birthday, kid.
Thanks.
All right, Ms. Stennett, your name. This is 2502959. Trefibio versus Stennett. Ma'am, your name?
My name is Mariah Stennett.
Mr. Trefibio, your name, sir?
Philip Trofibio.
All right, ma'am, how did you come with funding?
So I am getting a partial of $2,399 from my MDHS application. And then the September balance of $1,100, I will have September 12th, making a full payment of.
Sir, why don't you give me your breakdown as to how much is owed? I need you to tell me, first of all, how much rent there is to retain possession.
Okay, Your Honor. Currently, the rent would equal $3,300.
It's $1,100 per month?
Yes, sir.
And then are there late fees?
Yes, sir. We discussed this a few meetings ago. They came out to be a total of $700, and you knocked them down to $500.
How many months of rent? How many months of rent?
Three months of rent.
No, I never knocked them down to 500. I don't give $165 a month. I'll give you 50 per month. That's the best I'm going to do.
Yes, sir. I think that's what you did. Your Honor.
Well, then that's only 100 because she wouldn't be late for September, rent, right?
Well, she will be on the 12th.
I know, but yeah, I'm going to give you $100 in late fees.
Okay.
And then you have a $55 filing fee. What was your service fee?
$44.95, sir.
All right. So do you have any other out-of-pocket costs?
No, sir.
So she owes you $34.99.95, right?
Yes.
The initial $3,300 did not include any late fees, correct?
Correct, sir.
All right. So here's what I'm going to do. Ma'am, you're going to have all of this by the 12th.
Yes.
All right. Sir, you're going to have to present a judgment. It's going to be judgment after hearing. The writ date in this case will be September the 12th, but you have to bring that up here. Can you come up here and fill out a motion now? I mean, a judgment now?
Yes, sir. I could come up. I could be there in a half hour.
Perfect. Come on up here, Jennifer. Lisa, tell Jennifer or Linda, whoever, that to have him fill that out and to bring it right to me, and I'll sign it if you would, please.
I can hear you, Your Honor.
Okay, so you got that? You understand?
Yeah, you need a judgment.
Correct.
After hearing.
Right. 30. And so he's going to prepare it, and the writ date will be on the 12th.
Okay.
All right. Good luck to you, sir. Ma'am, best of luck to you both. Thank you both.
Okay. See you shortly.
Thank you. John, that is to go down to the Mount file. Woodhaven Place versus Clarence and April Walker, 2503262. Anybody here from Mr. Pallett's office, Linda?
Your Honor, I'm sorry. I'm just getting on here because I was in Judge Hessen's courtroom. I just got off.
I just brought him in. I brought them all in.
Oh,
thank you. I don't have Mr. Pallets here though, right? Oh, there you are. Okay. Well, we got a newbie here, eh?
Good afternoon.
Okay, your appearance?
Danielle Polly for Woodhaven, PA 46.
All right. I haven't had the pleasure before, have I?
I don't believe so.
Well, nice to have you. Ms. Walker, your name, ma'am?
April Denise Walker.
All right. So we adjourned this so you could speak with a lawyer. Did you get a chance to talk to a lawyer?
I did.
All right. So, counsel, just tell me the total amount due. And I'm sure they told you. I limit. Oh, what? I just told him 50 a month. I apologize. It should have been 70 a month. I raised those. I cap late fees at 70 per month. Can you give me a total amount that's due?
Total, including late fees and the court costs that are limited at $70 per month. Correct?
The late fees.
Yeah. So I have the total being $4,540.79.
That's the total amount.
That's the total amount.
And give me the breakdown now.
Yep, that is rent of $4,182.86. Late fees of $140. That's $70 for 2 months. And then court costs of $217.93.
That includes the statutory attorney fee, right?
Correct.
Ma'am, do you owe that amount?
Yeah.
Can you pay that?
He said I would have to, the lawyer said I had to the 12th to pay it.
Correct.
Okay. So yes, that's what I'm
Can you pay it by that date?
I was hoping that he would have gave me just to the 19th, but my dad is trying to pull some money
Here's
out of.
what I'm going to do. Here's what I'm going to do. Counsel, I'm giving you a judgment for $45,4079. The writ date will be September 12th. If defendant pays $2,600 by September 12th, writ date extended until the 19th. So if you can pay $2,600 by the 12th, I'll extend the writ date until September 19th, but you have to pay the rest of it by the 19th then.
Awesome. Thank you, Your Honor.
You're welcome. And you're going to prepare the order like that, right? And send it over, Ms. Paglia?
That's correct. I'll put those terms in the further order.
Nice to see I can make somebody happy once every 7 years.
Yeah. Thank you so much.
Good luck.
You too. Thank you. Bye. Thank you.
Is that it for you, Ms. Paglia?
That's it for me. Have a
great day, both of you. Thank you.
Have a great day. Thank you.
You're welcome. Bridgewood versus Amila Covington and Armani Covington. And by the way, tell them that's going to have to be a default against Clarence, Linda. I'm so sorry. I should have taken that. Default versus Clarence.
Okay.
Okay. Would you call them and tell them they need to submit a default as to Clarence, please?
Sure.
Thank you. Bridgewood versus Amila and Armani Covington, 2503295. All right, Amila, your name?
Amila Covington.
Armani
Covington.
And who do I have here for Mr. Levine? Okay, Mr. Burns?
Yes, good afternoon, Your Honor.
Good afternoon to you. Your appearance?
Good afternoon, Michael Burns, P87855 on behalf of plaintiff.
Where do we stand here? You guys owed as of the 25th, $1,405.82. Do you still owe that plus September rent?
We paid August rent already.
How much is owed, counsel?
And which matter is this, Your Honor? I apologize. Covington or Murphy?
Covington.
Covington, Your Honor, we are showing total due of rent $2,273, cost $231.82 for a total due of $2,504.82.
What are they?
Hang on, slow down. 2273 plus 241 or 2263? Counsel?
Your Honor, I'm showing rent of 2273 plus costs of 23182.
Oh, 23182. My apology. All right. Do you agree that you owe that amount, Amila?
No.
How much do you owe?
We paid the one for 108 that was discussed last time. I don't know if the system didn't update.
Mr. Burns?
Your Honor, if you give me 1 second, I am seeing the last payment from my client. They're noting that there was a balance brought in today of 1,174. So there was a payment plus September's rent posted. So that's what brought us to the 2273.
1174, you said?
Yes, Your Honor. That was the previous balance, I believe.
What is the rent?
What is the rent, Your Honor?
What is the rent?
I'm sorry, and just to clarify, on a monthly basis or total?
Monthly, September, how much?
Your Honor, monthly rent is $1,099.
Okay. Well, how much do you owe, Amila? I can't just have you say we paid this. You tell me how much you owe.
September's rent for $1,100.77. As I log into the portal, that's what it's currently saying.
Counsel, call your client. I'm passing the case, please. Give me
Thank you,
that
Your Honor.
case. Call your client. You guys don't go anywhere, and I'll come back to Bridgewood. People against Nelson, Ronaldo, Pineda, Blasco, 25Ms, 577, 125 A and B.
Good afternoon, Your Honor.
Good afternoon. How are you?
I'm doing well, thank you.
Your name?
Evelyn Zillow, certified court interpreter.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give it that.
I'm sure that Mr. Bennett has told you. I'm at a loss to even explain what your thought process was that morning. I can't even wrap my mind around any bit of this, that you would pull a gun and fire into their motor vehicle.
I did not shoot into their motor vehicle. Don't say anything else.
All right. Courts consider the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. Ms. Tranter, I'll ask you, are the victims on board with this recommended sentence?
They are, Your Honor. We've discussed.
All right, the court has considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So on the felonious assault count, Mr. Bryant, the court's going to order you to serve a minimum term sentence of 2 years, a maximum term sentence of 3 years. On the gun spec, you'll be serving a sentence of 5 years, and by law, that must be served prior to and consecutive to the felonious assault count for a total of 7 years to 10 years in prison. Do we have a jail time credit? I'm sorry.
Not from probation. I can look up one.
All right. The court will find that you're indigent for the purpose of any fines, costs, or other financial sanctions. Is there any request for any restitution?
I don't believe so, Your Honor. No restitution. No. Okay, no restitution.
Judge, for purposes of clarification, I know you received a 5-year gun specification.
5-year gun spec must be served first.
Correct.
And that it must be served consecutive to the minimum term sentence I ordered on the felonious assault,
right, which
is 2 years.
Correct.
That's a Reagan-Tokes case, so it's a minimum term 2, maximum term 3. So that comes up to 7 to 8 years.
Right. I thought the course was 7 and 10. That's why I was asking.
Oh, did I say 10?
Yeah, I don't want to have to come back. I thought you said 7 to 10, Judge.
It's 2 to 3 plus 5, so
Correct.
it's 7 to 8 years.
That's
only
my
1 year. Okay.
Yes.
If I said 10, I apologize.
13 to, yeah.
All right. It is possible for you to earn 5 to 15% against your minimum sentence for good behavior. The court has a right to deny your good time credit, A hearing would be held to make that determination. Regardless of whether you receive good time credit, you'll be released when you finish your minimum term unless the Department of Corrections determines that you must remain in prison for bad conduct. The court is not involved in that decision. If you're not released when your minimum term ends, you will serve an additional specified period of time. If given a new release date, you will serve until that date unless you are again denied release. This process could repeat until you are released or you serve your maximum term sentence.
Judge, I'm looking up by his social security number because the name search is giving me no credit, but I think he's got a couple of days at least.
I believe it's 4 days.
I think you're right. SQL is not coming up, but I would agree that there's 4 days credit, Judge.
All right, 4 days jail time credit. You're also subject to a mandatory period of post-release control. So upon your release from prison, the Adult Parole Authority will supervise you for up to 3 years, but not less than 18 months. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time you get sentenced to. Yes, sir.
Now, what about if, now with my current address, based off my release, and I move and I live with somebody else, will I need to update my current address with the courts once I get released? Based off my,
you're not going to be on supervision with the court once you are released. It will be with the Adult Parole Authority.
Okay.
They are the ones that you're going to have to keep notified of your address, but somebody will be in contact with you and to give you all those instructions prior to your release. Okay. It is mandatory PRC.
Okay.
All right. You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Tranter, is there anything else?
No, sir. Thank
Mr.
you.
Bennett.
Nothing, Your Honor.
All right, this time, sir, you're going to be remanded into the custody of the Warren County Sheriff's Office for transport to the Department of Corrections to begin serving your sentence. There's a deputy coming up behind you. Make yourself available to be placed into handcuffs.
Okay.
Are they going to be able to look and see what medications or they need to have just come with him? So you try.
That you will make a true and accurate translation between the court and the parties.
Yes, I do, Your Honor.
All right, sir, what is your name?
Señor, ¿cuál es su nombre? Ronaldo Pineda.
You're charged with no license
Usted lo han acusado de
on person and speeding.
y también exceso de velocidad.
You have the right to a lawyer. I'll be happy to give you one now. Would you like a lawyer?
Usted tiene el derecho de tener un abogado defensor. Si quisiera tener uno, si quiere tener uno, le nombro uno ahora mismo. Yes.
All right, so John, take it right to Mr. Mohammed. Tell him he's got to do that now, okay? All right, thank you. We'll see you back here if you can tell him that.
Yes.
What else do you have?
Thank you, Your Honor.
I'm not sure.
This is going across the aisle.
Yeah, right.
Yeah, but make sure he understands that that's got the interpreter. Angela Marie Rellinger, 214-725-324.
Judge, the victim's on Zoom.
Okay, your name, ma'am?
Angela Marie Rollinger.
And who is the victim?
Angie Marie Renana Contrastato.
Okay. Her mother?
Yes.
Okay, so you were notified. By law, we have to notify you when somebody's, by law, they're entitled to early discharge half the time. We notify the victim on an assault case when somebody's entitled to early discharge. So any case that involves a victim like that. So do you have any objection to her being discharged early?
No objection, Your Honor.
You assaulted your mother?
Yes, it was dropped down to a misdemeanor. And I did the probation. There was a 10-month period. And the halfway mark was March for August.
You two been talking? I see I made no assaultive, abusive, or intimidating behavior, not a no contact provision.
Yes, we made up and I actually moved back in with her.
Raise your right hand. You solemnly swear or affirm on the penalties of perjury that the testimony you'll give in these proceedings will be to hold to yourself, you God.
Yes.
Since you were in court in front of me when I sentenced you on March 4 of 25, have you been arrested?
No.
Any new charges?
No.
Prosecutor says, if defendant full compliance, no objection, defer to the court's discretion. I'm going to go ahead and dismiss your case. I sincerely wish you well. I hope you remember this. Don't no more of this nonsense, okay?
Thank you.
You with me? How old are you? Pardon?
25.
You working?
Yes.
Where at?
I was at a restaurant trying to Brilliant Schoolhouse. And I'm a mother also.
Well, congratulations. Show that child an example, boy or girl.
I have 3, 2 boys and a girl.
3 kids. Whoa. Good luck to you. Please dismiss. Good luck, ma'am. Thank you very much. I wish you well. All right. Mr. Burns, if you're ready, tell me. Do you have anything else?
Just a minute, Your Honor. I'm wrapping up with my client. I apologize.
Take your time.
I have a Bankovich file, but I think he might be a walk-in with
Mr. Bankovich?
Shumke. Yes, Richard Shumke might be representing. Lisa might know him.
Lisa, Mr. Bankovich is here. Who is representing him?
He had cases with Judge Hessen. Your case is was in warrant status. I'm not sure if she handled that or if she sent him to see an attorney.
Did she handle that?
I think she did. She showed the warrant, failure to show presenting. I got confused with it.
All right, give me the file, please. I'm just gonna, people against Bankovich. Donald Allen Bankovich, 25G306532. Come on up to the podium, sir.
Yes, sir.
Why'd you get confused about the date? Your name?
Donald Allen Bankovich.
Why'd you get confused about the date?
With the cases getting combined.
Okay, Donald.
I had for Jennifer Coleman for.
Well, I'm going to go ahead and set a sentence date. I'll continue your bond. Bond is reinstated, okay? When you didn't, but you have to show up. If you don't show up next time, bring a lot of money with you because I'm going to set a high bond. Do you understand one another?
Yes, sir.
Good. Sentence date, Lisa.
September 11th at 8:30.
September 11th at 8:30 in the morning. September 11th at 8:30 in the morning.
November 11th?
September.
Yes, sir.
September, right?
September 11th, 8:30.
If you want a court-appointed lawyer, you fill out a petition for one, okay?
Yes, sir.
So I'll let you fill out a petition. You didn't have a lawyer before, or did you?
Court appointed.
Yeah, you fill out I'll just give him a court-appointed lawyer, Lisa. I gave him one before. That's good, John.
Okay.
Thank you. Recalling Bridgewood versus, go down the hall and we'll give you your notice, sir. Bridgewood versus Amila and Armani Covington, 2503295.
Good afternoon, Your Honor. I was able to get a hold of my client. The Covingtons did make several payments. There was one on the 29th and one that was today. That's why we didn't have updated numbers, so I apologize. The total due on their account before court cost is $1,100.77.
So they owe 1,177 plus 250 or 231.82. So that's 1,332.59, right?
That's what I have, Your Honor.
All right. Do you agree that you owe that amount of money?
No. Because that should just be, it should be just September rent it should be due, and that's not technically late yet. So I'm not understanding where the additional $200 is coming from.
Well, you have to pay the court costs. They had to file.
But we paid that for August. That was included in August. They haven't filed anything for September.
How much did you give them a check for?
For $1,405.80-something.
That check has not been cleared, Your Honor. What I have from my client is there was a payment made on August 29th of $704.91, and there was a payment made today of $703, Your Honor.
So that's the $1,400.
That's fine.
Hey, slow down. Let's do this. Take your time. How much did you pay August 29th?
How much did you pay, Amelia?
Ma'am?
700, I can't remember, 700 and something, half of whatever the.
All right, hang on. Come on, guys. You got to be more prepared. Hang on. You got to be more prepared than this.
We are prepared.
Hang on.
We're not prepared.
No, you're not. You can't even tell me. Listen, I don't want to quarrel with you. I got a lot of people here, and I just want to move the case along. Counsel, tell me the amount that was paid August 29th.
August 29th, Your Honor, $704.91 was paid.
Do you agree that that was the payment?
Yes.
Okay, what's the next payment that was made?
There was a payment made today, Your Honor, of $703 even.
All right, so they paid $1,407.91 or 41?
91, Your Honor.
$1,407.91. You initially told me it was $2,504.82. So should we not take off $1,407.91? Or not?
Yes, Your Honor. That would then equal $1,096.91. My client is saying that there is $1,100.77 due and owing. So it's a discrepancy of about $4.20, just under 20 cents. So if
I'll give you the judgment for $1,096.91.
That's fine, Your Honor.
You guys agree that you owe that at least?
Yes.
Writ date will be September 12th, so you have to pay by September 12th, okay, you guys?
Okay, thank you.
Do you understand?
Yes.
All right, so you got to pay him $1,096.91 by the 12th. So long as you do that, no writ will issue. But I am giving him a judgment after hearing, okay?
Okay, thank you.
All right, have a good day. Thank you. Bridgewood versus Stephanie Murphy, 2503298LT.
Good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
All right, Ms. Murphy, good morning. Your name? Ms. Murphy, come on up here and tell me your name, please.
My name is Beth Murphy. I'm a daughter.
Your name?
Stephanie Murphy.
I know, I remember. I got it. You can't.
I apologize. We were here last week.
I know. I just can't let you represent us. Ms. Murphy, tell me your name, please.
Stephanie Ann Murphy.
All right, what do you think is owed on this one? State your appearance, Mr. Burns.
Yes, good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff. We're showing rent to retain of $2,593, costs in the total of $191.11 for a total due and owing of $2,784.11.
Do you agree that you owe that amount, Ms. Murphy? I can't let you represent.
I know, but she has Alzheimer's. I should have told you that last.
You got to get a lawyer. You got to get a lawyer. I just can't, I cannot let you do that.
All right.
Was another payment made that makes this less than $27.84? No? I'm asking you.
Me?
Yeah.
No.
Okay, so she agrees that she owes that amount, right?
Well, we haven't been living there. She hasn't been living there since like late May, early June because of bed bugs. We were forced out. She was forced out of there because of bed bugs. Can't stay there. I was paying. I handled her. I handled her bank account.
Did you turn over the key?
Yeah. I spent the entire summer cleaning out that place, throwing everything out for her.
All right, let's slow down. Let's slow down. All right. Department manager, your name.
Ginger Pelk.
Did they move out?
I've not received any keys from them.
They're on the counter.
Well,
wait a minute. Did you guys have a complaint of bed bugs?
Yes.
Ma'am.
Sorry. I'll let her and Tim Murphy talk.
Did you have a complaint of bed bugs?
Yes.
Who said yes? I'm asking you guys. Come on, just
Your
tell me
Honor, Your Honor, I have no knowledge of it.
I'm talking to the Bridgewood's manager here. I'm asking her.
I thought you were talking to them.
No,
yes,
I'm talking.
They did have bed bugs. I found out because they told the neighbor, had it treated. And she said, well, I haven't been living there fully because of the bed bugs, but we've not received any keys. We've treated the apartment. There is a co-signer also on the account, and I tried calling him too, and no response from him.
Who's him?
I'm sorry?
Who's the co-owner? I mean, the co-lessee?
It is the father. So it would be Stephanie's, I believe, ex-husband.
Tim Murphy.
Tim Murphy, come on here. Jeez. Tim Murphy, you got to come up here.
He's on Zoom.
I'm on.
You got to start your video.
Okay, I'm on.
All right, I'm going to ask you to take your hat off and tell me your name.
Timothy Murphy.
When did you leave there?
I never lived there. I was co-signed it because Stephanie's income from Social Security wasn't enough to cover, so I added my name to the co-signing it so they could afford the apartment.
You didn't add him as a party, Mr. Brown.
Your Honor, if I may speak to that, I'm looking at the lease right now. I'm not seeing Tim Murphy as a co-signee. I'm seeing, at least on the lease that is dated beginning October 14th, 2024 to October 31st, 2025. The only signatory on the lease is a Ms. Stephanie Murphy.
All right. Okay.
Well, I did sign it though.
Slow down. You did or didn't?
I did. Ginger knows that.
There is a separate form that our guarantors signed. They're not on the original lease. They signed an addendum to the lease that they are co-signing.
All right. So we have a problem here. Doesn't look like you have all your parties in the case. And
Your Honor, I think we can resolve this. If they're indicating that they haven't lived there and the keys are on the counter and they don't intend to retake possession of the premises, then this case can be resolved by my client simply receiving the keys from the defendants. It sounds like they don't intend on living there in the future. And rather than going too far into the weeds with this, if my client can just receive possession of the premises back, I think we can have this case resolved.
Stephanie, you need to listen to me. Okay? They are offering you, and if you don't understand something I'm telling you, I want you to put your hand up and I'll start over. Fair?
Sure.
They're offering to enter into a consent order of dismissal where there will be no judgment entered, and you can turn over the keys by, let's say, tomorrow at 4:30. And if you do, that the case will remain dismissed. Is that agreeable with you?
Yes.
So counsel, will you prepare a consent order of dismissal, no judgment, and say the case is dismissed with prejudice? However, defendant shall turn over the key to the property and vacate no later than September 3 at 4 o'clock.
Your Honor, I have no, I'm sorry.
You will.
I'll wait for the court to be done. I apologize, Your Honor.
That's all right. I'm used to being interrupted. Case will remain dismissed with prejudice so long as defendant turns over the keys. Is that fair, Mr. Burns?
Your Honor, I have no problem with those terms, but I can't dismiss it with prejudice, but I'd be willing to do everything else. I have no problem
You're
doing
not going to turn around and sue him for rent, right?
I can't speak to that, Your Honor. I mean, it's
Well, I thought you just said you were going to dismiss it if they turn the keys over. If not, we're going to have the battle now.
And Your Honor, I understand that. My
You
client, I
understand
don't
what I'm
want
saying?
to.
Because I don't know that they owe you anything if the bed bugs were that bad and they haven't been in there. So why don't you go to a breakout room and talk to the apartment manager? Because it's not fair to them to have them turn the key over and then they have you start a lawsuit against them.
Your Honor, I don't want to.
You think I'm wrong, it's okay, but I'm not going to do that otherwise. It's not fair to them.
Let me ask my client this. Ginger, would you be willing to dismiss the case with prejudice?
And an indication that no money judgment will be pursued for past due rent, period.
Yes, I can't make that decision, but I'm going to tell you my corporate office will go after them for rent. The bed bugs were not caused by us.
Oh, then that's fine. We'll just adjourn it a week. You're going to have to get a lawyer, Stephanie. If you're going to fight this on a bed bug issue, you're going to have to get a lawyer. Your daughter cannot represent you.
Okay.
That's what I'll do. I'll adjourn it 1 week and we'll set it for trial. Everybody has to come in. I mean, it makes sense. Did you not ever tell the manager you were leaving?
Me?
No, I'm talking to the party here. Did you ever tell the manager that you were leaving, that there were bed bugs on the property?
Yeah, they.
Hang on, ma'am. Talk to me. I don't want to be interrupted over here. Did you ever tell the manager, either in writing or in a phone call?
Emanation.
Why am I getting interrupted here? I'm not.
I muted him, Judge.
What's that?
I muted him. He's just talking.
Thank you. I want to know if you ever told the manager or wrote the manager and said, we got bed bugs, we're moving out.
Yes, they were aware of it.
You told them, answer my question. Did you? Okay, you got to step back, young lady. I cannot let you do this. Stephanie, stay right here. Just talk to me. I don't bite. I just want to know if you told the manager that you were leaving and that there was a bed bug issue.
They knew about the bed bugs.
I didn't ask you that.
They're right next door to us. And I had told them and showed.
Told who's them?
The next door neighbors, the people who rent from.
I'm sorry?
Our neighbors, our next door neighbors.
You told your next door neighbors?
Well, yeah,
Did you tell the manager?
she is the manager.
Do you live next door to her?
I do not. I found out they had bed bugs because they told their neighbor that they weren't staying in the apartment because they had bed bugs. That is how I found out.
When did you find that out?
Oh, I would have to go back through the emails. I was not under.
When did you find that out?
Hold on. I'd have to go back through my.
Take your time.
Put that one on the top.
What day, Stephanie, did you move out of there? Do you know?
It was, probably 2 weeks ago.
2 weeks ago?
No.
Ma'am, sit in the back now. Next move you say, I'm sending you out of the courtroom. Sit in the back.
She's my daughter and she lives with me.
I know, but I can't allow her to represent you.
Can I say something, Judge?
No, you can't. You're not even a party either. Stephanie, I want you to look at me. If you're feeling pressured, tell me, Judge, I'm feeling pressured, and I'll let you go hire a lawyer and come back next week. Okay?
Okay.
Do you remember when you told so you're saying you stayed in there until mid-August?
Yes.
When did you have it treated for bed bugs? No, I'm asking you, the manager again. I did not catch your name, so I've got to ask you again. What is your name?
My name?
No, the manager. Are you
I'm
listening?
sorry. I'm looking at her account. My name is Ginger.
Ginger what? Pelk?
Yes.
PELC?
Correct.
All right. When did you have the bed bugs treated, and when were you notified by the neighbors or Ms. Murphy or anybody else on the planet that they'd vacated the property?
Yeah, I was trying to pull up the emails, her account. I can tell you they were charged for the bed bugs on July 1st. I charged them for the treatment.
Why'd they get charged?
Because they have the bed bugs. Nobody else had the bed bugs.
Okay.
Our normal extermination does not cover bed bugs.
Okay, July 1 is when that happened, right?
Yeah, that's when they got charged. They paid July's rent too.
So all we're talking about here is half of August rent or all of August rent, right?
Yes, Your Honor.
Yes.
Well, man, when were the bed bugs treated?
I'm trying to pull up that right now. Bear with me. I'm sorry.
You lived there after the bed bugs were treated, Stephanie? Stephanie, look at me.
Oh.
Did you treat the bed? Did you remain in the property after the bed bugs were treated?
Yes.
For how long?
I don't know, maybe a couple of weeks. It wasn't very long.
So I pulled up the addendum to the bed bugs. So they were charged July 1st for the bed bugs, but because they left their cats in there while they were not living there, and they didn't get the clothes properly prepped, we did not end up treating until July 29th because they moved out and left 2 cats in there.
Wait a second. You just got done telling me that they left 2 weeks ago. When do you think they left?
They weren't staying there because of the bed bugs, but there was still clothes in the bedroom, mattresses, couch, kitchen table, and 2 cats. I know the cats they had to remove for us to treat on July 29th. But I have not heard from them.
All right, Stephanie.
They told me they were not.
I would like you to come up here and I'm going to ask, Mrs. Murphy. What's your name again? Beth what?
Murphy.
Come on up here. Now, I'm going to tell you, I'm going to ask you questions or two because I'm going to let you be kind of a witness here. But if you answer out loud without me directing you again or without me addressing you again, I'm sending you out the hallway. Do we understand one another?
Yes.
All right. Now you can tell me when. Were you living with your mother
Yes.
until she moved out?
Well, we both moved out.
I understand. Okay. When was that?
Late May, early June.
hang on. You're saying you left late May, early June.
Well, you guys are living there.
She's saying, Stephanie told me 2 weeks ago, which would make it around August the 17th or 18th. They say you had cats in there after they knew of the bed bug problem in July. Is that true or false?
Cats, yes.
Well, the cats were still there, right?
Cats were still there.
Well, then you didn't move out. You never turned your keys over. You still were occupying the property. I'm just amazed that you guys didn't communicate with the manager. I think a lot of this could have been avoided. You don't just tell your neighbors, I'm moving out, I got bed bugs. And leave cats there and then come back and I'm not keeping you up, am I?
Sir.
Sir, I'm not keeping you up, am I?
No.
Okay. I don't want to keep you up.
No,
Okay, all right. Mr. Burns, can you not just go in a room and talk to this Stephanie Murphy with her daughter there and see if you can't resolve this?
I'm willing to do that, Your Honor. I do have one other matter I'm trying to wrap up in a different court. So if the court puts us in a breakout room, I'm willing to address these things. I just want to let you know.
Put you guys in a breakout room with Mr. Burns. Stephanie really has to do the talking. It looks like you got to handle this better. You can't just walk out of there, leave cats in there. Technically, you still occupy the property.
Right.
You didn't turn the keys over. Was this still during the lease period, Ms. Pelk?
Yes, they're still in a current lease until the end of October.
Did you guys stop and think about that before you started leaving? You're going to get stuck paying this rent again. You can't just move out. I'm just telling you. Where do you live now, Ms. Murphy? Stephanie, where do you live?
I'm still there. No.
I get Alzheimer's. I understand Alzheimer's. I cannot let you represent her. Ms. Murphy, talk to me. You just explained to me that you left 2 weeks ago, right?
No, no. I did not leave 2 weeks ago. I left recently.
What's recent?
Yeah.
Okay, so you've been in there the whole time.
Yeah.
I'm going to let you guys go talk to Mr. Burns. He has another courtroom to go to. My court officer's going to take you to a computer and you can Zoom with Mr. Burns. He'll explain it to you and we'll go from there, okay? I'll pass this case. Thank you. Nelson Ronaldo Pineda, Velasco, 25M77125A and B. You know, this is going to kill me. You guys can't call in the prosecutor. Mr. Muhammad.
Good morning, Judge.
How are you?
Good afternoon, I should say, and always a pleasure here.
You too.
Sean Graziani appearing on behalf of Ronaldo Pineda Velasco.
Ms. Villarreal, you are still under oath.
Understood, Your Honor.
Sir, state your name again.
Señor, usted vuelve y diga su nombre.
So, it is not that I do not believe that these interpreters should make the money they make. I want to be clear about that. They do. They deserve it. But, and I'm not trying to quicken the process. What is it about 1 week that is going to prevent you from settling today?
What's happened, Judge?
And by the way, does he stand mute and waive formal reading? Does he?
Yes.
Yes, he does. We have a formal reading.
Mr. Muhammad, your name.
Good afternoon, Your Honor. Mohammed on behalf of
I don't believe in quick justice. I would like to think the two of you and everybody else that ever comes in here knows that. But this is a no ops on person charge. We're paying this interpreter a lot of money. No disrespect, she deserves every nickel. But can you guys figure out a way to try to resolve this today rather than in a week?
So, Your Honor, the reason that they need a week, and it's not the people that need the week, it's defense does.
In fact, I want more time.
Yeah, so the defense actually asked for 30 days. I informed them that we would not adjourn it for 30 days. I said we would adjourn for 1 week, assuming the court would accept it. However, defense would like to submit a copy of the defendant's Colombian driver's license as well as the international driver's license in this case. At that point, I've already spoken with the trooper who would dismiss the no watch.
Fair enough. $100 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Pretrial will be next Tuesday, September the 9th at
9:15.
At 9:15.
Judge, can you also advise Mr. Velasco that in addition to the international license, that he also needs the Colombian license?
You need both the international and the Colombian licenses.
Necesita presentarle la licencia de Colombia y la licencia internacional. Ambas licencias.
Es posible, señor.
Do you understand that, sir?
¿Usted comprende eso, señor? Yes.
And I must have that emailed so I can present that evidence to Mr. Mohammed. Is that understood?
Usted me las tiene que mandar copias por correo electrónico para yo poder enseñárselas al señor fiscal, el señor Mohammed, para que tenga eso también.
Por la abogado Graciani email. My email.
Send me Mr. Graciani's email.
Okay, thank you so much. I'm brushing up a little bit of my Spanish.
You better. You're doing better than I did. And I had Spanish for 2 years, but unfortunately that was like 48 and 49 years ago.
Please.
See you next week.
Muchas gracias, señor.
Good luck. Thanks a lot. Make sure he goes down the hall and you give him that notice and tell him again. Thank you so much. Thank you. Jaleel Harris, Jaleel Armani to Sean Harris, 25M 577-119A and B. Your name?
Jaleel Harris.
You didn't show up last time.
I had an incident in Ohio. I was beat and had to go to the hospital. So
you got a fight?
No, I got all set up. So yeah, they had my phone and I forgot the date and had court.
All right. Today is a state docket day. We are going to send you to the prosecutor. Would you like a lawyer?
I don't got a lawyer. So
No, do you want one? I'll give you one if you want one.
Sure.
Give him a lawyer. So that one needs to go down, that one to the lawyer. We'll go from there. Mr. Williams, what are you here on, sir?
Your Honor, I've got several cases. These are probable cause conferences.
Okay. Mr. Shemke.
Here's Williams.
Oh, you're the prosecutor.
Snyder is ready also, if that's in there.
Patrick Fallahy, Patrick Darren Fallahy, 25W719969. Okay, Mr. Williams, your name?
Rodney Williams, on behalf of the defendant, 247888.
Your name, sir?
Patrick Darren Fallahy.
All right, so we're going to go with the exam next week.
Judge, the victim's on Zoom also.
Where's the victim? Who is the victim?
Put my note on the register too.
What's that?
They sent this.
Here?
Yeah, if you look at my note, you'll see. I don't know if Mohammed saw it or not.
Can I have the defendant call me as well afterwards?
Yeah, but now I'm getting handed paperwork. I need Mr. Mohammed and I need the victim to show up and state the name. Victim, you need to sign in.
This case belongs to the domestic prosecutor.
Okay. We need the domestic prosecutor, whoever that is. Victim, you need to sign in. It says victim Falahi. I need you to start your video.
Oh, I have the video, but
What's your name?
Nicole Beach.
Okay. Let me check a couple things, counsel. I don't even see. Okay, you've got the bond conditions in the lien, right, Lisa?
I can check, Judge.
I've got them right here. I'm gonna reiterate them. Can you give me a bond sheet? Stay right where you are, Ms. Beach, please.
Okay.
The prosecutor's on Zoom.
Oh, there you are. How you doing, Ms. Louie?
Hi, how's it going?
Good, you?
I'm good.
Yeah, you had a good honeymoon and all that? You're all.
Thank you.
Well, state your name, please.
Noor Alawi on behalf of the people.
All right, I need a bond sheet and there was something that was emailed to us about a bond violation. So let's start with that. But first of all, I'm going to go ahead. I'll note that Judge Burton he must have been sitting as the magistrate that day, or the visiting judge that day, I should say. Ordered no contact, no assaultive, abusive, required to obtain a tether. I need to check one thing, counsel, real quick. So no contact. Who's Ashley Roulette, Ms. Beach?
She's my friend who was with me that night and was also assaulted. Or almost assaulted.
All right. Cool. Nicole Beach or Ashley Roulette, no contact with them at all. No contact with prosecution witnesses. You're not to possess firearms. That was not ordered. If you have firearms, you have to bring them over to the Woodhaven. I have no firearms. No firearms, no dangerous weapons. You have a tether?
I do, sir.
All right, let me just see something here. Who lives at 23020 Fairway Drive, number 204, Ms. Alawi?
I believe that is
it's me.
Complaint witness here. I'm just going to double check.
Mr. Williams, I need you back in here. I don't know what happened. I just see a picture of you.
Sorry.
That's okay.
Sorry about that. I just don't want to be wrong here. I have.
That was the location of the
That location is complainant Miss Beach's home.
Okay. So you're not to enter the property address or go near 23020 Fairway Drive.
Yes, sir.
Unit 204 in Woodhaven. Lisa, we're going to have to communicate. I have no idea what the terms of this tether are, but you're not to be within 2 miles of the victim,
Yes, sir.
her residence, or place of employment.
Yes, sir.
You have to get that straightened out, Mr. Williams, with the tether unit at the sheriff's department.
I go there.
Hang on. I don't know what the judge ordered. I can't tell. He didn't fill out a bond sheet, I don't see. But those are the conditions. You're not to be within 2 miles of the victim or residence or place of employment. You're not to leave the state. You're not to violate a law. You must appear in court as directed. Again, no contact with Nicole Beach or Ashley Roulette. You cannot write, phone, see, text, email, or communicate with them or have anybody else do any of those things for you on your behalf. You also have to show up in court. Are we doing September 9th on this, Mr. Williams?
The 16th, Your Honor.
The 16th. Okay, so you have the right to a preliminary examination within 7 days of the date of the probable cause conference. Today is the probable cause conference. Are you not available next Tuesday, counsel?
I am not, Your Honor.
Your lawyer has a conflict, so he's asking me to adjourn it for 2 weeks. Do you waive your right to have the exam within 1 week of the date of the probable cause conference?
Yeah.
Anybody force you to do that?
No.
Preliminary exam will be September 16th, Lisa, at
10:45.
At 10:45. I want to be clear. So, Mr. Williams, you're going to have to deal with the tether unit. Make sure they understand that tether is to prohibit him from going within 2 miles of the victim, her residence, or place of employment. And that goes for both victims, Ashley Roulette or Nicole Beach. So he's going to have to get that straightened out. I don't quite understand what Judge Burton ordered totally. So that's the best I can do. Do you have any questions, sir?
I do not.
Now, there was an issue here about bond, and we got an email. I'm just looking at it. It says Patrick Fallahy was arraigned out county over the past weekend, instructed in his release order not to have any contact or direct or indirect contact with Nicole Beach. 2 separate reports have been made by Nicole where she stated he's texting her and calling her, requesting a hearing to violate his release order and have his personal bond revoked. Apparently, your client doesn't listen very well. Do you want to confer with him as to whether or not he wants to plead guilty or wishes to have a hearing?
Yes, I would, Your Honor.
We're going to put you in a breakout room to speak with your lawyer. When a judge tells you no contact, I want you to understand that's what they mean. Do you understand me? That means you cannot write, phone, see, text, go anywhere near them, have anybody in the country or the world contact them for you on your behalf, whether by text, phone, letters, in person, email, otherwise. So we understand one another.
Yes.
Go talk to your lawyer. I'm dead serious about what I'm saying.
Yes, sir.
Your Honor, if I may be put into a breakout room with the victim here.
Yeah, we'll put you in a room with Ms. Beach, and you're going to be in a room with your lawyer, and then you're coming back, and we're figuring out how we're going to proceed here. Do we understand that? Cody Snyder.
And if it's easier,
Cody.
I'm sorry.
Is Mr. Carmen Cody Snyder's lawyer?
Coming in right now.
People against Cody Clayton Heath Snyder, 250-706-513. Mr. Carmen, your name?
Good afternoon, Your Honor. Michael A. Carmen, P73824 on behalf.
Mr. Snyder, your name? Start your video, sir. Your name?
Can you hear me?
Yeah, your name?
Cody Snyder.
We're setting this for September 16th. You need instead of the 9th, right?
Yes, Your Honor, please.
Sir, you have the right to a preliminary exam within 7 days of the date of the probable cause conference. Today is the preliminary exam. If I adjourn this per your lawyer's request, that means the probable cause conference, the exam will not take place within 7 days of the date of the probable cause conference. Do you understand that?
Yes, sir.
Do you wish to give up that right?